All right, we're going to call this meeting to order. I'm Senator Tammy Nichols, and my co-chair is Representative Heather Scott. We welcome everyone today. Thank you for being here and for participating in this task force. We're going to start out with just a quick introduction. I'm just going to introduce everybody that we have that serves on the committee, and then we have a statement on the task force that we want to read just to remind everybody the purpose of this task force. So again, I'm Senator Nichols from District 10, and I have Representative Heather Scott as the co-chair. She's from District 2. And then we have Representative Alfieri down at the end here, Representative Barbara Ehart, Representative Marco Erickson, and then online with us today we have Senator Carl Bjorky and Senator Cindy Carlson. Senator Kaiser should be joining us hopefully later today, and then we also have Representative Gannon and Senator Ruckty, but I think they both had summer plans going on, so hopefully they'll meet with us at the next one. So I'm just going to go ahead and start with the statement on the task force and what our scope is, and then I'm going to turn it over to Representative Heather Scott to read the second portion of that scope. So this task force has been convened because our constituents have shared a lot of concerns with us about outcomes in child custody cases. Our purpose here is to study how child custody and family laws are being interpreted and applied by Idaho courts. We're trying to decide, one, whether Idaho courts in general are applying the law in a way that's consistent with legislative intent, and two, whether we as a task force should recommend changes to the law that would provide courts and citizens with more clarity. We also want to explore whether there are policies the legislature could enact to ensure that everyone involved in a child custody case has fair access to court processes and adequate legal representation.
We also want to make it clear that the legislator's role here is limited. The Idaho Constitution separates government powers into different branches. The legislature makes the law, but the courts decide the cases, and we are not here today to second guess the decisions of individual judges or to undermine the integrity of the courts. While the co-chairs welcome public feedback and encourage robust discussion, our purpose is to consider the law and how it's being applied and whether there should be changes in the law. We ask that everyone presenting or testifying to the task force keep that purpose in mind and be aware that if things get out of too far down a road, we might just stop you and kind of rein it back in a bit. This is a very deep topic, a very emotional topic, and we want to make sure everyone's heard and just respect everyone's time.
Thank you. So we have a schedule that we will try to adhere to as closely as possible because we want to be mindful of everyone's time. So we appreciate, again, you being here. And so we will act as the timekeepers as well, just to make sure that we're trying to stay on task. We do have a scheduled lunch break for 12 o'clock. So that's going to be an 12 o'clock-ish. And but we will try to adhere as closely to the time as possible. When we get down to the public testimony today, we are trying to keep that at about 3 minutes, but we do want to allow for questions and answers for everybody that's here today because as committee members, our purpose is to gather that knowledge and to process it and to be able to ask questions to everyone that is here to present and to testify. So we're going to go ahead and get started with our first speaker. So we have Chief of Police from the City of Meridian, Tracy Bastrachia. Hopefully I said that correctly. Am I good? Okay. Welcome to the committee. Thank you for being here, and go ahead and state your name for the record and proceed.
Chief Tracy Bastrachia.
Oh, and you might have to flip the mic on. There you go.
Chief Tracy Bastrachia, Chief of Police, Meridian Police Department, past president of the Idaho Chiefs of Police Association and one of their legislative committee members. Thank you for asking me to be here because child custody issues, like many civil matters, can present significant challenges for law enforcement. officers in the state of Idaho. We rely on Title 32 of Idaho Code, which governs child custody and domestic relations to guide our responses. However, real-world situations often complicate enforcement. Some of the common challenges that we face, and just so you know, I will not take up 25 minutes. I'm used to doing 3 minutes here, so. Some of the challenges certainly that we face are conflicting jurisdictional orders, which while not as common as they once were, parents with multiple ties to multiple states may attempt to manipulate the legal system by quote-unquote judge shopping for favorable outcomes. And this can lead to conflicting custody orders from different jurisdictions. So we may be dealing with somebody in Idaho, however, there's been a custody order issued in another state that may conflict with orders that have been issued here. Jurisdictional declines. One state may decline to exercise jurisdiction if another is deemed better to handle that situation, adding further complexity to our officers' responses to those calls. Enforcement limitations. Custody orders are generally enforced through civil motions and contempt proceedings. So consequences such as are usually modified custody, maybe fines, or rarely, not typically, but jail time. And the issues with this part of the system is it doesn't give any immediate relief to the aggrieved parties. So oftentimes they're left very frustrated by how the system is playing out because there are certain things we just cannot afford. And one of those things that we cannot enforce. One of the things that we do have the ability really to respond to immediately is a non-custodial interference or non-custodial violation where a non-custodial parent may be withholding that child from the custodial parent. And then that is something certainly that we will take the steps to get a warrant and have that child removed for child safety purposes. But where we really get into the meat of the matter for us are those joint custodial disputes where one party picks up the child for their set visitation for a week or maybe even a month or whatever it is, and then when it's time to return the child, they either don't show up or they refuse to return that child. And so we really don't have any ability to make them give that child back because it is a civil matter. And when we reach out to our prosecutors and the attorneys, we're usually given the same advice, right? Unless we can prove that there is a safety issue there, then they need to work it out through their attorneys and through the courts and with the judges. And again, that can be very, very frustrating for the person who has an order that says, but the child is supposed to come home with me. And oftentimes we're dealing with those because one parent maybe is more of the disciplinarian and the other parent lets them run free. And so they don't want to go back to the house where there are some rules set up. And so oftentimes we're faced with that situation and having to deal with that. And then the only other thing really where we really get involved in is a lot of times where there just isn't a custodial agreement. And what we've seen is nobody's gone to court yet. They had a quote-unquote gentleman or ladies agreement on how they're going to have custody of the child, and then one of them refuses to adhere to that agreement. And really our hands are tied at that moment because there is absolutely no order in place for that. And so we have no ability to enforce any of that or return the child to either one of those parents. So it can get very, very tricky for us. Our officers have to walk a very fine line between enforcing civil court orders, respecting the rights of both parents, and ensuring keeping that child's safety as our highest priority. And so that kind of narrows it down to really law enforcement's involvement in these child custody disputes. And with that, I'll stand for any questions that you might have.
Thank you, Chief Pastor-Chia. Committee, any questions? Representative Ehart?
Thank you, Madam Chair. Thank you, Chief. So if you would, you kind of hit at what I think we've heard a lot about, which is, when one parent doesn't abide by what the agreement is and the child isn't returned in whatever scenario you presented, they call you. It's probably a weekend, they're not calling the judge, so they call you. Would you do two things?
Yes.
Walk me through what happens then at that time when an officer receives
Yes.
a call, and then also, maybe I should save it for the follow-up. At some point, when it goes back to the courts, right, a judgment's going to be made again, and what changes? Like nothing. It's like without police involvement, it seems like nothing would change, and it just keep going back to the court and go back to the court. Do you see kind of? Okay.
Excellent question.
Okay.
Excellent scenario, because it's
faster, Jay,
exactly
yeah.
what we face at times. Sorry.
No, you're fine.
Senator Nichols, Representative Ehart, that is absolutely an excellent question. So when an officer receives that call, the first thing they do is they will call the party that is, or meet with the party, depending on where you're at, and get the information of what they're aggrieved about, why the child isn't being returned, those things. And then normally we'll ask, do you have a copy of the paperwork? So we can read the paperwork, and we look over the paperwork. And then we will reach out to the person or the parent who is failing to return the child, and we will either meet with them or we will talk with them over the phone, because sometimes, honestly, they may have even left the state on vacation with the child. And we will try to explain, is there a legitimate reason why you were unable to get the child back, right? Did your car break down? Have you made an attempt to work through this with your the other parent, so that you can come to a agreement where the child will be returned in a timely manner? And honestly, we're usually pretty good at that. We're usually pretty good at convincing somebody that they need to return the child. But if they don't, then they do have to go to the court. If it's something where we're concerned that there's a safety issue for the child, we will actually go to a judge and get a warrant ourselves. But normally they'll go to the court, and if they're still refusing to return the child, a judge can issue a warrant for us to remove the child from the home. Those are fairly rare, at least for us. We haven't had to utilize those very often.
Follow up?
Yes, Madam Chair. So then just the follow-up on, as it's, and maybe that's what you're kind of answering, as it continually goes on, if they don't respect what you've asked, at what point does a judge, or do they, because a judge can only issue for you guys then to enact, at what point would maybe the offending party maybe finally be held accountable, and how would that be? Again, because the courts can issue whatever they want. Is there ever a point where, for lack of a better word, they're arrested, or are you ever involved in that?
Chief?
Senator Nichols, Representative Earhart, that is probably a better question for a judge. But yes, we may be involved where there is a warrant where they have to spend some jail time. But again, I don't know that I don't remember us ever actually having to arrest somebody on one of those warrants. Doesn't mean that it hasn't happened. We're a fairly large department, so our officers arrest people on warrants often.
So follow up?
Yeah.
So, Chief, then basically the scenario where the police get involved, and I'm assuming, I know you can only speak for your department, but you interact with other departments, and I'm sure we'll have other police at some point also respond, but are we then, that's probably pretty common throughout the state, I'm assuming, with what you just described, right?
Senator Nichols, Representative Earhart, absolutely.
Okay.
We have these conversations all of the time, the frustrations that officers have, and the precarious position oftentimes that they're put in the middle of, because when somebody calls, they're not sending the fire department, it's the police department that is going to respond and try to fix that problem, and people have that don't really understand the system, because it is a very confusing system, even for officers. And as you can imagine, for lay people, they expect us to go and solve that problem right then and there. And that is rarely the case.
One last follow-up.
Yep, go right ahead.
So, Chief, then, and this is a little bit loaded, and I don't expect you to actually answer it all here, and maybe it's something you could share, but given the experience that all of you have had, and knowing that it's a convoluted system or whatever, I forget how you just described it, do you or any of your officers, have you come to any answers that would be useful in solving this problem?
Chief?
Senator Nichols, Representative Earhart. The answer is, I'm not sure. We have lots of ideas, certainly, but there certainly is, the system can be better. There is no doubt about that. And that's what we want. And I can tell you from personal experiences with some family members, I know the frustrations firsthand of some of the decisions that are handed down and the lack of accountability in a lot of these cases.
Okay. Representative Scott?
Thank you. Thank you for coming today, Chief. I'm curious, your interactions with health and welfare. So someone calls you on a child case that they haven't returned the child in time. You show up and you see bruising on the child. Is that when the safety kind of comes in and where you would maybe pursue something? And what does that process look like? Do you call health and welfare? How often does health and welfare get put in this mix of parents fighting over court orders of when they get their child?
Chief Pastrachia?
Senator Nichols, Representative Scott. Again, excellent question. And the answer to that is often. Yes, if we saw bruising, if there were safety concerns, we would remove that child at the very least under our imminent danger laws, if we felt that there was an imminent threat to that child, and then we would follow up. We work with health and welfare a lot because a lot of times rather than call the police, they are given the referrals and they will go and they investigate every referral of abuse. And even though oftentimes those referrals have been proven to have inaccurate information or over and over again, they're still going out and they're investigating them, which we would expect. And they normally will call us and we will go with them to look into those types of cases.
Okay. Good. Representative Erickson?
Thank you, Madam Chair. I just had a question specific to the amount of custody exchanges that you have to supervise in your capacity. I have an experience with that. How frequent is that where you're supervising the exchange piece?
Chief?
Senator Nichols, Representative Erickson. I guess, again, I would have to say it depends. Actually, physically sitting and watching those exchanges, very rare for us. But what we do have is oftentimes judges require the exchange to take place in our parking lot. And so those are going on all the time. And if there's a dispute in the parking lot, then we respond to that dispute. But they're often in the orders for those child custody exchanges that they have to go to our police department to do those exchanges.
Okay. You good? All right. Representative Alfieri?
Thank you, Senator. Chief, you mentioned on occasion that there are issues when there are handshake agreements rather than a written agreement. And sometimes, I know in divorce, sometimes it takes a while to get a formal agreement written. So what happens in a handshake agreement when you've got a dispute between parents on returning a child? What do you do?
Chief?
Senator Nichols, Representative Alfieri. Basically, we don't do anything unless there's a safety concern.
Okay.
Follow up?
Nope.
No, you're good. Okay. Yes, Representative Scott?
Thank you, Mr. Chairman and Chief. My other question is, so what happens, like, I know there's always like runaway or child was kidnapped, or how does that play in with the custody cases? And then I'll add one more question. Do you have someone on staff that basically just deals with this stuff all the time, or is it just every officer is trained in these issues?
Chief?
Senator Nichols, Representative Scott. So we do have officers that have more training for these types of issues. Usually it's an investigator, but the initial response is going to be a patrol officer. Now, if it's a parental kidnapping, that's an easy one for us. We right, the Amber Alert's going out. We're getting all the resources up and going and trying to track down that child if we can prove those elements of that crime. But if it's just the parents refusing to bring that that child in, then again, we try to staff it with the supervisor. They try to have those conversations with the prosecutor if needed to see which direction we need to go. And quite frankly, unless there is a danger to that child, unless we can show there is a danger to that child, it's probably, we're going to wait until they voluntarily return the child or until a judge issues an order for them to return the child.
Follow-up?
Follow-up, thank you, Madam Chair and Chief. So I'm just trying to understand when the criminal part comes in. So if someone doesn't return a child, is it, and you can't get a hold of them, would the Amber Alert go off? Do you wait a certain time? What does that look like? You're like, oh, this is the guy that always drops the kid off late. What, I mean, do you look at the facts of it, or do you have a certain timeline you go by? And then just to touch on that last question, the child runaway stuff. Like, if the kid says, I'm not leaving dad, or I'm not leaving mom, when does that become a runaway child? And I'm sure it's messy, but I'm just curious if you give us some insight into what that looks like.
Chief.
Representative Nichols, or Senator Nichols, sorry, Representative Scott. So back up just a little bit and deconstruct it. First off, we try to look at the totality of the situation, and we will go back and we will go through our system and see, is this a common occurrence where dad's always an hour late or mom's always an hour late? Or is this something where we have a history of they're holding that child as leverage through the prior reports and prior reporting that we've had? Is there a history of any type of abuse from the parent that is holding that child? And then we will make that determination with the totality of those circumstances. If we literally cannot get a hold of them, that is when we would have a conversation with a prosecutor and more than likely work to get a warrant for the child or even possibly for the parent. On a runaway, again, a little dicier because technically, they're not a runaway. They're with a parent that has the authority to have that child. And so we would take the report, we would document the child custody issue, and they would use that when they go back to court before the judge in family court.
Representative Ehart?
Thank you, Chief. It's kind of the same question that Representative Scott had, and so I don't know if I was trying to see if I thought you answered it. So, parental kidnapping versus not return. Now, I understand you're saying you'd look at the totality, if there's a totality, which to look, and we just had a kidnapping in southeast Idaho, that with two children, feeling like they've been taken back. So, I guess I'm just a little more on, because it could happen the very first time. So it's primarily what triggers a potential kidnapping or contacting the prosecuting attorney is if they won't contact you or return a call, or I'm not sure if I heard that correctly.
Chief?
Senator Nichols, Representative Earhart. Just the fact that they won't return the call initially is not what triggers it. It really is the totality, the facts of the case, what we know. Because a parent feels, which oftentimes we get, right? I feel like they're not going to return my child, or I feel like we can't go on what the feelings are. We have to go on what is in front of us, what the facts are. What does the court order say? Does the court order say you absolutely cannot take that child out of the state? If it says you can't take the child out of state, and we can show that you have taken that child out of state, we will get a hold of a prosecutor and see about getting a warrant for parental kidnapping and bring that child back into the state, as well as obviously the parent on an arrest warrant.
You have a follow-up?
Follow-up. So you're probably aware of the kidnapping and the Amber Alert in southeast Idaho
Yes.
with the two, 14, 15-year-old, I think, boy and girl. But, if you wait too long, I guess I'm just also kind of wondering, how long would you wait? Because, if exchanges were going back and forth and all of a sudden somebody flees, but you don't know that they've fled, I probably am more interested just because of what's just happened in Idaho Falls.
Chief?
Senator Nichols, Representative Hart. I completely understand that. But again, what we can do, we can only do what the law says we can do. And so we literally have to focus on what are the facts that we know before we make this determination. Because I think you would all agree as well, you would hate to see somebody get a warrant for kidnapping when it's just I'm an overdue parent bringing my child back.
All right. We have Senator Carlson that's online with us, and she has a question.
Yes, can you hear me?
Yes, we can.
Okay, Senator Nichols, Chairman Nichols, and
Chief Basterchia?
Chief Basticia, hard to pronounce. Anyway, my question is, from county to county, are you all communicating with each other? So if you have a parent who's had a history of problems in one county and something else takes place in another county, is that information that you're referring to used statewide?
Chief?
Senator Nichols, the answer to that would be it is not. So we're all on different reporting systems. Unless it's a criminal charge, then they would have that information statewide if somebody's been arrested on an actual crime. How it is shared is if we know somebody is residing in another county and they're not bringing that child back, we will contact the agency in that county and we will have them do a welfare check on the child and make contact with the parent and that child to see why they're not bringing the child back or why they're overdue in bringing that child back.
You have a follow-up, Senator Carlson?
I'm not sure if it's a follow-up or not, maybe a comment.
Okay.
I have a concern that statewide they're not able to share information because you have parents in multiple areas of the state who, their child might go missing. It might take hours and hours and hours to decide for that county that they are in at the time to actually communicate with the one that has history. That's a concern for me. Thank you.
Thank you, Senator Carlson. Did you have a comment to that, Chief?
Yes, thank you, Chairman Nichols, Senator Carlson. And my comment would be, I absolutely understand that concern. I can only tell you what we would do, and we wouldn't wait to see if we think the child's in danger. If we know that the parent is in another county and the child is overdue, we are going to either make contact with the parent if we can by phone and have that conversation with them. And then we try to contact the agency in that county, whether it's the sheriff's department or a city police department, and have them make contact with that person if we're unable to.
Thank you. Representative Scott?
Thank you. Chairman and Chief, can you tell me the difference between an incident report and an offense report? Someone asked me that and I wasn't sure.
Chief?
Chairman Nichols, Chairman Scott, I think I would have to say it probably depends on your agency. So an incident number is what is assigned, the way we look at it, is what is assigned to a call when it is dispatched to our officers. So oftentimes they won't take a report, they will put notes into the incident number on why there was no report taken. And it may be this is a civil situation, but if it's a child custody dispute, we're taking that as an offense report, as a department report number. So if we believe this is child custody dispute, we have all that information in front of us, we are taking a report.
Okay. All right. Chief, I have a question for you. When you talked about the challenges with state to state, what do you think would be a good solution as far as being able to gather that information or have that information available? So if there is these disputes going on from one state and they're in our state, and how do you see that playing out maybe better than what we currently have going on?
Senator Nichols, that's a great question that I don't have an answer to. I do know, and I don't know the acronyms to it, there is a system that is supposed to help stop those jurisdictional issues, those jurisdictional conflicts. I believe it's some type of compact throughout, at least in the Western United States. But that doesn't mean that it is always going to be available. I would hope that any judges that are issuing these types of orders, if they know that somebody is in another jurisdiction, that they're actually able to go into the court system in our state or vice versa and see if there are any other orders floating out there. I don't want to say I would assume because that always gets us in trouble, but I would think that they would have that ability. I would hope so that they know that any rulings that they're making aren't in contradiction with a ruling that another judge in another state has made.
Okay, thank you. All right, any other questions? Okay, I think that is good. Thank you so much, Chief,
All right.
for
No,
being
thank you
here.
very
We really
much.
appreciate that, and thank you.
Thank you. My pleasure. Thank you for having me.
All right, next we have up is Honorary Kyle Shu, I believe. Did I say that right? You can correct me, and I will apologize up front if I do not get your names correctly, but we'll have you introduce yourself on the record anyway, but we welcome you to the committee, and thank you for being here. So go ahead and introduce yourself, and then go ahead and proceed with your presentation.
Thank you, Madam Chair. It's Kyle Scow.
Scow, sorry, I'm sorry.
Someday you will have
I
a
was not
speaker-
even close.
Someday you'll have a speaker with a pronounceable last name, I suppose.
You're fine. Thank you
Madam
for
Chair.
being here.
Of course, thank you. Madam Chair, I'm Kyle Scow. I am a magistrate judge here in Ada County. I've been an attorney for about 15 years at this point. During that time, I've worked both in private practice and in public service. For the last 3 years, I've been a magistrate judge assigned to a family law docket. So prior to coming here, I had a chance to review this committee's charge, and it's my intention, I guess, to address the two components of that charge. Broadly speaking, I think the task force is looking at how are the courts applying the law and whether improvements can be made on that. And then secondarily, is there some improvement that the legislature can make to Idahoans' access to justice in the family law context? So it's my intention first to give an overview of what the law is, and then I'll walk you through a case as it would flow in a typical case through my courtroom. And then I'll talk about what the courts have been doing to try and assure access to justice for Idahoans. It's my intention to be helpful here, so if at any point there are questions, please feel free to interrupt.
Thank you.
So the U.S. Constitution guarantees parents the right to direct the upbringing of their children. That is a right that is jointly held by both parents. Consistent with that, the Idaho legislature has given us Idaho Code Section 32717B, which presumes that in child custody cases, parents should have joint custody, both joint legal and joint physical custody. Joint legal custody means that both parents should have a seat at the table when discussing major decision-making in their child's life, such as medical decisions, educational decisions, religious decisions, things like that. Excuse me.
Mm-hmm.
Joint physical custody refers to frequent and continuing contact with both parents. Figuring out exactly what that looks like, we apply the factors that the legislature has given us in Idaho Code Section 32717. So essentially what we're doing at the courts is resolving disputes between parents. To the extent that parents are in agreement about anything, the courts generally just won't even hear about it. So to walk you through how this works in application, I'll give you an example of sort of the simplest child custody case that would wind up in my courtroom, which is a divorce involving minor children. So the way this would start would be with one parent or another filing a divorce action against the other parent. And they would file a petition for divorce in which they would explain why they want a divorce, what they think child custody should look like after the dissolution of the marriage, how assets should be distributed. And then the other side would file a response. That response would lay out in very general terms, here are the things that I disagree with in the petition. After the response has been filed, that would be the first time sort of that it would come to a judge's attention in a contested case. There would be a scheduling conference scheduled. A calendaring order would go out telling the parties, here's the time and place to show up. usually over Zoom in my courtroom. I imagine that's true statewide. In my courtroom, they would also receive a copy of Idaho Rule of Family Law Procedure 401. Now, that rule governs this exchange of information that's supposed to take place during the pendency of this proceeding. It's going to
Real quickly, Madam Chair,
Sorry, Representative.
may I request that he put the microphone, I'm having a hard
Oh,
time hearing.
yes, go right ahead.
I'm
Sorry.
so sorry. I'm so sorry.
No, go right ahead. Yeah, thank you.
Madam Chair, Representative Earhart, can you hear me okay? All right, I will do my best. Please feel free to remind me. All right, so Idaho Family Law Rules of Procedure 401 would go out with that calendaring order, and that would explain to the parties this information that needs to be exchanged, because what we have to deal with is child support and child custody. We need to know what their incomes are. They need to share tax returns and pay stubs, things of that nature, as well as a detailed explanation of what they think the parenting plan should look like. Also, while we're waiting for the scheduling conference, court staff would reach out or would review the records in the file, as well as records statewide, to see whether there are any red flags that require some additional scrutiny, whether a party has a civil protection order against them, whether there's a criminal no contact order, pending charges, allegations of child abuse or domestic violence. If any of those red flags exist, then I can order a sort of brief investigation into those issues. What that would involve is court staff reaching out to both parties and giving them the opportunity to explain their side of things. So that will generally happen prior to the scheduling conference. I would have a report outlining what both parties' positions are. So we come to the scheduling conference, and we'll be discussing generally, if no red flags exist, whether mediation is appropriate. I think it's, I think I can probably speak for most judges out there that we believe that parents are in a better position to sort out child custody than judges are. So to the extent we can facilitate an agreement between two parents, that would be ideal. You know, judges care about children, but it's abstract. Parents love their children. They know their children in a way that a judge never would be able to. So usually what will happen is we'll order the parties into mediation early on so that they can try and sort this out with a third party there to guide them through the process to see if there's some common ground that they can reach. We'll set it for a status conference a little ways down the road, probably about 6 weeks. At that status conference, we'll discuss whether mediation has succeeded or not. If mediation has succeeded, they're self-represented litigants. I'll explain to them the paperwork they have to get in front of me in order to resolve their case finally, point them in the direction of resources so that they can get some help filling that paperwork out. If mediation has failed, that's the point at which we need to set things for trial. I would set a pretrial conference and a court trial. Prior to the pretrial conference, there are several things that can go on. I know that there is a discussion about what happens if there were, you know, there's just this gentleman's agreement regarding custody. Well, the court has the ability to act on a temporary basis during the pendency of a case in order to address those things. We can enter temporary custody orders, temporary support orders to make sure that the kids are taken care of and that both parties' rights and responsibilities are well defined. That doesn't happen in every case, but we are empowered to do so. Furthermore, if there are allegations of abuse, we are required by law under Idaho Code Section 32717C to I just realized I gave you a wrong citation earlier on. It was 32717B is the presumption of joint custody. In any case, we're required to send Idaho Department of Health and Welfare out to do an investigation into the allegations of abuse. Furthermore, we can order something called a brief focused assessment. That would be a mental health professional going out and investigating some discrete issue. Is there appropriate housing for the children? What are the children's wishes as to custody? Are there mental health or addiction issues with one or both parents that may affect their ability to parent? We don't receive any sort of recommendations as to what child custody should be out of that, but we are given a report about here are my findings and here's a little bit of analysis on that. And then finally, we can order something called a parenting time evaluation, which is a very extensive investigation conducted by, again, a mental health professional. Oftentimes, it's a psychologist. We'll also get people with masters of social work, things like that, doing these. What they'll do is a comprehensive view of both parents. They will go out and review medical and mental health treatment records, addiction treatment records. They will interview both parties. They will interview the children. They will watch the interactions between the children and the parents. They can actually conduct psychological testing if they're qualified to do so, so that they can tell us are there mental health issues that need to be addressed in a parenting plan. And ultimately, a parenting time evaluation will contain detailed recommendations as to what the court should do, applying those factors that I talked about in 32717. So then we'll come to the pretrial conference, and this is sort of the last stop prior to trial, typically. At this proceeding, generally speaking, mediation will have failed by this point. At least in my court, it's several weeks before trial. It's about 5 weeks before trial is what I shoot for. The reason for that is I would like every opportunity to try and encourage the parents to reach a resolution. So what I'll be discussing with them is there anything I can do to break the logjam? Or is this something where there's just intractable differences and you need a decision from a judge? There are several things we can do at this late stage. One of them is called a judicial settlement conference. It's sort of another shot at mediation, but with a judge being the mediator. They're not right for every case, but oftentimes a judge offering that perspective to these parties about here's how I would think about this if we were to go to trial, offers them some insight into what the likely outcomes may be at trial, and then help them get to common ground again. At times, we also involve mental health professionals in those. We'll have a social worker. Sometimes we'll have an attorney mediator come and join us for those. But again, it's trying to find some common ground between the parents. The other thing that we'll do at a pretrial conference is discuss the nuts and bolts of trial. Oftentimes, these are self-represented litigants who, they don't do this for a living. So what we'll do is talk about how the proceedings are going to go. Generally speaking, how do you get your evidence in front of the court? The order of operations, who I'm going to hear from first. By this time, they will have given me witness lists. If there are lots of witnesses, I may talk about time limitations for them, and just to make sure that things get done in a timely fashion. So assuming all of the attempts to reach a resolution have failed, that's when we come to trial. At this hearing, we'll hear from both parents. Generally, we'll hear from both parents. They don't have to testify if they don't want to, but generally speaking, we'll hear from both parents. We'll hear from other witnesses who may have something to say about each parent's parenting abilities. It could be family, friends, neighbors, experts, psychologists who can come in and talk about discrete issues of parenting in this particular dynamic. We could hear from the person who did the parenting time evaluation if one was done. And then after hearing from both sides, then that's the point at which the court has to make its findings of fact and conclusions of law. So that can either be done in a written decision or it can be done orally, just telling the parents what we find. But generally speaking, the findings of fact are, who and what do I believe, and why do I believe it? And then the conclusions of law are applying those 32717 factors and 32717B, applying those and saying, here's what I believe is a child custody schedule that's in the best interest of the children. And I did want to talk a little bit about those factors a little bit more in detail. So there are exceptions to that presumption of joint custody. It's just a presumption. It's our starting point. If we find that one parent or the other is a habitual perpetrator of domestic violence, as defined in 396303, that's the point at which the presumption is flipped. And the habitual perpetrator of domestic violence it's presumed that they will not have joint custody, and it would be presumed that the other parent would have sole custody. That presumption can be overcome by a presumption of the evidence. So just what do we find is more likely than not? Do we think it would be more likely than not that, some sole custody in one area or another, legal custody in one area or another, saying one parent could make medical decisions for their child if there are intractable differences between the parents on some discrete issue? That often happens. And then we look at the wishes of the parents as to what the schedule should be, the wishes of the child. How do they relate to their parents and their siblings? How are they adjusted to their home, school, and community? What are the character and circumstances of everybody involved? That can be both the parents, step-parents, grandparents, anybody having significant contact with the minor children.
Judge Scow, can I
Yes.
stop you for just a minute?
Of course.
There's a couple of questions, so let's entertain those, and then thank you. Representative Scott, go ahead with yours.
Thank you, Madam Chair and Judge. Thank you for coming today. So you said that when you're doing the placement, that according to, I think you said 396303, you take into consideration domestic violence.
Correct.
Do you take that into consideration because it's in law, and are there other factors, in particularly like sexual crimes? Is that taken into effect? Is that not in law, or do you just decide that on your own, or how does that work?
Judge Scow.
So, Madam Chair, Representative Scott, I would say that if somebody has a criminal background, even if it's not specifically domestic violence, then I think we take it into consideration in terms of the character of the people involved. I can't promise you that everybody applies that the same way, but it's something that I think, generally speaking, judges would consider as the character and circumstances of the person involved. Secondarily, I just want to point out that domestic violence in the context of 396303 includes sexual abuse. So that would be, if it's sexual abuse of a household member, then that could be considered expressly under 32717B and 32717 subsection G.
Okay. Follow up?
I'll wait.
Okay. Representative Erickson?
Thank you, Madam Chair. My question is related to 32717B and the conflicts that could occur between health and welfare. For example, if they've gone in and done a child custody review due to a report, let's say a grandparent says, hey, I'm concerned here, they go in and find nothing, and then you, by law, are required to do further. When you have conflicting reports like that, how do you handle that in the court?
Judge Scow?
Madam Chair, Representative Erickson, as I understand the question, it's health and welfare has done this investigation on the one hand, and then I'm separately ordering another investigation. Is that what you're
Let's
asking
say health and welfare found nothing, and they decided that there's no risk to the family currently, and then there's still a report going on saying, like I hire a lawyer and I say, I want to prove that there's something going on in that family, right? Because I have a lawyer and I have the ability to get some, but I want something done, and they've already come in and said nothing's happening, and then now I'm in the court because I have a lawyer. So can you explain how that works there?
Certainly. So, Madam Chair, Representative Erickson, so if it's an allegation of abuse that comes up in my courtroom, I'm going to be getting the same report from health and welfare that they already did. When I get the reports that I order from health and welfare, they actually include a list of everything that they've responded to in the past relative to this child. If it's another kind of report, say a parenting time evaluation or a brief focused assessment, first off, they would have considered those reports in their assessment, so they probably would have had access to those. But at the end of the day, it's the court's duty to weigh the evidence that we receive and make our own findings of fact. We're not bound by what the Department of Health and Welfare finds. We can agree or disagree with them. I think we generally have a great deal of respect for the work they do, but at the end of the day, we have to make decisions based on the evidence that's presented to us in court.
And follow up? Are you good? Okay. Representative Ehart?
Thank you. And I know we've got a time, so I'll slow down on this, but I do have lots of questions at some point, depending on how much you have left. One of the questions that, since these guys had asked this, that I actually had in here, and now's the time to ask it. It seems odd to me, and this does seem to happen, it's one of the things that I've heard over the last few years, that if you have a marriage and there's been no reported abuse during that marriage to the police or anything, and then you get divorced, or you're going through the process of getting divorced, and all of a sudden these abuse allegations pop up. I don't know, I guess maybe just touch on that. That seems a little bit odd and a little bit convenient for one party or the other, doesn't it?
Judge.
Madam Chair, Representative Ehart, it's something that we consider in weighing the evidence, right? We have to consider whether these things are cropping up at the last minute, whether it seems as though these allegations are being made for strategic reasons, or alternately, whether this person was in a relationship that involved coercive control and they simply didn't feel safe coming forward. So ultimately, it's a very fact-sensitive determination.
Follow up?
Follow up.
So if we're in the case where you're in the middle of a divorce and you know, this seems to be something that occurs too. We have a hearing date, and then lo and behold, that hearing date's about to come up, and then allegations from the other party pop up that now have to be investigated. And the importance of that hearing date was the one party who maybe wasn't able to see their children. It may be, you know, the male or female, mom or dad, probably doesn't matter, that by these new allegations, it delays their ability now to, you know, plead their case and see their kids. How do we handle that? Because again, you're right. I mean, I understand that this is a tough discretion you have, but if there's one thing I probably have heard more of in my adult life, and as you said, or somebody said, many of us have seen it in our families, it's that. And it's frustrating.
Judge Scow.
Madam Chair, Representative Ehart, I can't say that you're wrong about that. The statutory scheme that we're given requires us to investigate these things. Ultimately, you know, the court's charge, as directed by the legislature, is to act in the best interest of the child, right? I think the bedrock of that is assuring that a child is safe. So if somebody is making allegations that concern the safety of a child, we are obligated by statute to give the Department of Health and Welfare an opportunity to investigate this. The current statutory framework gives the Department of Health and Welfare 30 days, and that can be found at Idaho Code Section 32717C. We are also required to put things on pause under that statute until such time as we have that report back. We are not allowed to make a final determination. We can still make temporary orders and things of that nature pending the outcome of the investigation. But we can't make a final determination until we have that report back from the department.
Okay,
Madam Chairman, very helpful. One last, you don't have to belabor this, but given the statutory requirement that you cited 32717C, I think, so if an allegation is made by one, can the other counter allegation, and then where does that put you?
Judge.
Thank you, Madam Chair. Representative Ehart, that puts us in a position where we simply can't make a final determination, but we will probably have to make a temporary determination. We'll obviously have gotten the allegations. We'll know the substance of them. Obviously, we won't have had a full-blown trial at this point, but we'll do our best.
Representative Alfieri.
Thank you, Madam Chair. Judge, thank you. I'm curious about the weight of testimony. Is there a precedence or a priority given to testimony given by, for example, health and welfare compared to a child psychologist that one of the parents might bring in?
Judge.
Madam Chair, Representative Alfieri, there is no precedent that says we are supposed to weigh the evidence in any particular way. In that regard, that's a nuanced question. But in terms of whether we're supposed to give preference to a forensic psychologist versus a Department of Health and Welfare report, We just have to make a credibility determination about what we think is most likely. And what we'll be looking at is the methodology of both reports. Does this seem to make sense to us?
And follow up?
That's good, thank you. No.
Okay. Representative Scott?
Thank you, Madam Chair and Judge. I'm curious, who has oversight over your decisions? So like, let's just say, or a judge, I'm not talking you personally, but just judges in general, make a lot of bad decisions according to people or someone. There's probably some complaint process, but is there a review of you personally as a judge or other judges? Obviously, these cases are super emotional, and so I'm just curious what that looks like, that process.
Judge Scow.
Madam Chair, Representative Scott, in terms of who has oversights over judges, the answer is kind of varied depending on what you mean by that. Are we operating within the bounds of our ethical responsibilities? Ultimately, the Supreme Court has the ability to review that. There's the Judicial Council, which I'm sure you're all familiar with. If somebody has a complaint about a judge and the way they've conducted themselves, then they can file a complaint with the Judicial Council. They'll do an investigation. As I understand it, they have access to the court proceedings. If it's something that a judge is alleged to have done in open court, the executive director will go and listen to that proceeding. Quite frankly, I have no knowledge of these things going on in the background until such time as the Judicial Council either requests a response from the judge or says that the complaint is unfounded and it's going to go no further. So in terms of whether I'm obeying the law, that's through the appeals process. So I'm a magistrate judge, which means that a district judge would hear my appeal. From there, the district judge's decision could be appealed to the Supreme Court and either heard by the Court of Appeals or directly by the Supreme Court, depending on whatever the Supreme Court wants to do with their docket.
Follow-up. Thank you, Madam Chair and Judge. I was looking at the appellate, or the rules, the family rules, and I noticed there was a pilot project in Magistrate District 4. That's what the document I pulled up. Is there different sets of judicial rules for family court for different areas in the state? And if you could speak on that District 4 pilot project, I would love to know more about it.
All right.
Judge Scow.
Madam Chair, Representative Scott, the pilot project, the only one I'm aware of was the promulgations of the rules of family law procedure. They were rolled out, I think, I'm going to say January of 2013. So this is the one. Okay, so in January of 2013, they were rolled out in the 4th Judicial District to see how they worked. And since that time, they've actually been adopted statewide. In July 1 of 2015, the family law rules, perhaps with some minor changes, were adopted statewide by the Supreme Court. So in terms of whether there are different rules statewide, each judicial district has a process by which the administrative district judge can promulgate local rules. I am unaware of any local rules that would be specific to family law, but potentially they exist in other judicial districts.
All right. And Judge, I have a question in regards to, you talked about some of the the mental health of co-parents and that sort of thing. So what reports or evidence do you require in that type of situation? Like, who do you get this from? So if there's a mental health allegation or a concern with a parent's mental health, can you just speak to maybe that process on its own merit?
Yeah. Thank you, Madam Chair. So it depends on whether I have the concern or whether one of the parties is bringing the concern. If a party is bringing the concern, they can, at their own expense, seek an order from the court to have the other party submit to a mental health evaluation. So that would be the way, and if one party has a concern that I don't share. If I have a concern about mental health, I can also order those mental health evaluations. They'll just say, here are the diagnoses. I'm not a mental health professional, so typically what I would do is look to a parenting time evaluation where I would have a mental health professional interview everybody and then talk about how that affects a decision in a child custody context. So parenting time evaluations and brief focused assessments, those are the court's experts. They're paid for by the parties, usually jointly, but at the end of the day, they answer to the court.
Okay. And just to follow up with that, so can any party bring up an allegation in regards to like mental health issues, and then if that happens, then does it have to be taken on and searched through to see if there is a mental health issue that's going on?
Madam Chair, no, it's the court's discretion as to whether to order those sorts of evaluations.
Okay. Representative Ehart?
Thank you, Madam Chair. And honestly, we say it a lot, but thank you for being here. This helps. So, couple of just general questions, if I could. You have a lot of discretion, and I mean, speaking of judges in these cases. One of the things I've noticed that there seems to be studies. There's been some real unique studies, including of a very dear friend of mine and even a family member that they had to go through. What determines what kind of study that one party may have to have, assuming there's no criminal record? I understand those kind of things, but what determines what one party may have to have if the other one doesn't have to have it? And is there a limit on how many studies? And I use that word generally. You know what I'm talking. Because these things cost money. So what determines that? Is it just kind of a gut feeling?
Judge Scow?
Madam Chair, Representative Ehart. So I want to address two things here. One is what determines what studies are ordered, and the answer is the judge. And what are we guided by? I guess it's a lot of experience. There are limitations. We are sensitive to the need to keep costs down, and quite frankly, it exists in implicitly exists in our Constitution, which guarantees a speedy resolution. I think coming with that is a cost-effective resolution. It's in the attorney's oath. In terms of the 4th Judicial District, I can't speak for other judicial districts. We have resources to pay for these things, so if somebody is truly indigent and can't afford it, it is something that I can order if I feel that there are issues of great complexity that it would assist me to have the input from a mental health professional. The parties can't afford it, then I can order that through Family Court Services. There are several clinicians who work down there who can do a parenting time evaluation for me. There are contractors in the Treasure Valley who will take funding from them to do a mental health evaluation. So does that answer your question, ma'am?
Representative Ehart?
Madam Chair, sir, kind of along those same lines then as a continuation. I've been able to look into some of the costs that maybe not your district, but others have to pay. It's pretty astronomical what some people charge. This is Barbara Ehart speaking. Divorce is a big business, and could we achieve the same results with less studies?
Judge Scow?
Madam Chair, Representative Ehart, speaking only for myself, I don't order them unless I find them to be necessary. So to the extent, could I achieve the same result without the studies? Yeah, maybe, but it might be random, right? Maybe I get it right, but for the wrong reasons. I, again, try and be judicious and understanding that these cost a lot of money. And to be frank, I've said it on the record a number of times, it's eye-wateringly expensive to privately pay for a parenting time evaluation. Tens of thousands of dollars, potentially.
Right. One last follow-up.
One last one?
Or at least for now. How long I know you probably are not tracking this. How long would you say, guesstimation, you're not held to anything, an average divorce takes, and any idea how much it costs, but particularly how long divorces tend to take?
Judge Scow?
Madam Chair, Representative Ehart, I don't know, and I can speak only for my own courtroom. Many of the divorces I have are uncontested. Those can get done in as little as 21 days.
Okay.
By statute, there is a waiting period. disallows me from ordering a divorce prior to 21 days after the serving of the summons and petition. In terms of contested proceedings, the way that I manage my calendar, let me do some math real quick. I could potentially have a trial done within 3 months if everybody's on the ball and doing their homework timely. The scheduling conference would be about 5 weeks after the initial petition, 5-6 weeks after the petition. If everybody shows up and convinces me that it's just ready for trial and just needs a trial, I would be setting trial a couple of months down the road. So,
Can we jump to Senator Carlson? or
No,
do you have one
we
more?
absolutely can. I just think we maybe need him to be a traveling divorce judge.
Okay. Senator Carlson has a question. Go ahead, Senator Carlson.
Chairman and Judge. Sorry, I can't remember your
Judge
name again.
Scow?
I can't pull it up either. What's that again?
Judge Scow.
Scow. I have a question about the parenting time evaluators. How are they chosen, and is the parent who has to comply with the parenting evaluation, are they given a list of evaluators that they can use, or how does that work? And my second question would be, is there a way for is it possible that some parents are requesting maybe things that are very expensive for the other parent, and is there a way that we could share those costs and make it so they're more of a reasonable request? I know those are two totally different questions, but maybe if you could touch on both of them.
Judge Scow.
Madam Chair, Senator Carlson, in terms of the selection of the parenting time evaluator, if it's brought by motion of a party, if one party is asking me to appoint one, they have to identify exactly who they want me to appoint. So that's under, I think it's Rule 1004 of the Idaho Family Law Rules of Procedure. One of the requirements is they tell me who they want. In terms of disparate resources between the parties, I can apportion the costs of this study. If I decide to order it, I can apportion it between the parties based on any number of factors. Separately, Idaho Code Section 32704 and 705 give the court the ability to award costs, forward costs from one party to another if there are disparate resources between the two parties.
You have a follow-up, Senator Carlson?
Yeah, real quick. So the other parent gets to decide who the parenting time evaluator will be? Did I understand that correctly?
Judge Scow.
Madam Chair, not exactly, ma'am. So Senator Carlson, what they would do is they would identify who they want, and then they would bring it before the court on a motion. The other side could then be heard on it. They could say, I don't think a parenting time evaluation is necessary at all. I don't think the particular evaluator that they've selected is an appropriate one. I think this other person would be a better fit for this case. So it's not as though one parent gets to pick. Ultimately, the judge has to pick, but they'll be picking from a list of providers who are identified by the parties prior to court.
Okay.
Thank you.
Thank you, Senator Carlson. Okay, one more question. Okay, Representative Scott, go ahead.
Thank you, Madam Chair and Judge Scaw. I'm curious, can you tell me when judges do gag orders or sealed documents, and what's the reasoning and why they do that with divorce or family law stuff?
Judge Scow.
Madam Chair, Representative Scott, so that's governed by Administrative Rule 32. Under Rule 32G20, in a child custody case, the records are automatically what we call exempt from disclosure. The public can't get their hands on this stuff without a judge's order. So in that particular rule, they talk about what the judge should be looking for in releasing it. And basically, are there allegations of abuse? Is there something that's embarrassing to the child? Something along those lines. After we review it, we're supposed to release it to whoever's requesting, so long as there isn't something like that. In terms of gag orders, that's governed by Rule 32I of the administrative rules. 32I and some of the case law surrounding it tells us that we're supposed to put this on the scale between the public's interest in knowing what's going on in their courts versus the interest of privacy of the parties. So if there's something that's embarrassing, defamatory, something along those lines that's contained in these records, then we could enter a gag order. Speaking only for myself, well, actually, let me tell you one more thing about 32I. It tells us that we're supposed to narrowly tailor that as best we can. Speaking only for myself, I tend to make those orders. It has to be a written order sealing documents. I tend to make those publicly available so at least the public will know why generally. Obviously, I can't identify what's in the sealed records in this, but why generally the court is saying that the public can't review these things.
Okay. All right. Okay. Okay. Representative Ehart. Okay. One more thing.
Okay, sorry. So just real quickly along that same line, because there are questions too along this line, can the Judicial Council review sealed records and the reasoning and all that behind there? Is there a means of reviewing that?
Judge Scow.
Madam Chair, Representative Ehart, I believe that the Judicial Council has access to, or at least the Executive Director of the Judicial Council has access to all the records, sealed and unsealed. Furthermore, we have to maintain, if we redact something, meaning black parts of it out to release to the public, we also have to maintain an unblacked out copy of it. So there exist all kinds of copies of this, and people can always ask the court to unseal these records.
Okay. All right. Judge, I'll give you just, we're going to wrap up, and I know we didn't get to everything, but we really appreciate you entertaining the questions. So if you just want to do a little wrap up for us, that would be great. Thank you. Thank you so
I don't
much.
have much of a wrap up, but I just did want to address something that Chief Basterachea had talked about. There were a lot of questions about enforcement. Essentially the court has, contempt is very difficult to prove. It's a crime in the typical sense of the word. So a private party has to prosecute it and prove it beyond a reasonable doubt. So it's very difficult for, say, self-represented litigants to go down that road. So recently the Supreme Court has promulgated Rule 815 and 816 of the Idaho Family Law Rules of Procedure, which allow for an expedited process in custody matters to get before the court in a couple of weeks. To have, if it's an ambiguous order, we can clarify it. If somebody's messed up and not turned over a kid when they should have, then we can order makeup time and things along those lines. So that was the one thing I just wanted to talk about, but I appreciate the opportunity you've given me. Obviously,
Thank you so much.
The court would be happy to respond to anything else at this
We
task
really
force has.
appreciate it. Thank you. We'll probably have to have you back to go over some more things with us, but thank you for your time today.
Thank you very much for having me.
Yeah. All right, we're going to go ahead. We have one on child support. Katie Haylett, she's Child Support Bureau Chief in the Division of Self-Reliance, Department of Health and Welfare. We are welcoming her via Zoom today. Katie, make sure you can hear us, and then go ahead and introduce yourself for the record and proceed.
Hello, yes. My name is Katie Haylett. Just making sure everyone can hear me.
Yes, you're good.
Yes, okay, perfect. So I am the Bureau Chief of the Child Support Program within the Department of Health and Welfare. So I have a PowerPoint presentation that I will get up, and can everyone see that?
Not yet.
Oh, give me one sec, because let's see.
We can see you still.
Okay, one more button. How is that?
We see, yep, there you go.
No. Oh, there it is. Okay, perfect. Give me 1 second. Okay, so I will just get started with the history of child support. So the Child Support Enforcement Program was established under the Title 4D of the Social Security Act, and it was signed into law in 1975. So we're celebrating 50 years of child support. It created a federal and state partnership to enforce child support obligations. The mandated states to establish a child support enforcement program agency to collect payments, locate parents, and establish paternity. In Idaho, the program is administered through the Department of Health and Welfare. Numerous Idaho statutes grant child support services its authority and outlines enforcement remedies available to us to collect child support and enforce court orders.
Ms. Aylett, can I have you,
Yes.
can you expand your screen for the presentation portion of it for us?
Sorry, let's see.
We can see it, it's just not quite big, so.
It's just not big. Okay, let me try to move around. Oh, I see that. Is that better?
Yeah, now just open up the screen just a little bit more. It made it bigger. Yeah, click on that.
Goodness,
Click
I
on that square thing I think that you were on.
Oh, maybe if I did. Let me try one thing. I don't usually use Zoom, and I have it on a, let's see.
Maybe just go into.
I am not seeing where.
Yeah, click on
Make it
that one.
bigger.
Does that one work?
This one right here?
Yeah, try that one.
So that,
Or can you just?
I don't think,
Okay, okay. The committee's saying they can see it better now, so let's just go ahead and do
okay.
that. Thank you.
Leave it right there?
Yep, thank
and
you
I
so
just
much.
closed it. I'm so sorry.
No, you're good. Go ahead.
And you can still see the screen?
We can. Yep, you're good.
Okay, so processing child support cases. So under Idaho Code 32710A, specifies that payments for child support orders pursuant to any decree or other child support order are to be paid through the Department of Health and Welfare Child Support Services. Child support is only responsible for processing and tracking these payments and are not actively enforcing the child support orders or locating parents. In this receiving only, which is the non-4D setup, the receiving parent typically handles the communication with the other parent through their employer or, if applicable, regarding payment arrangements. So in those non-4D cases, we get the court order, we set it up in our system, and we just track and distribute the payments. Under Idaho Code 32710A, it grants child support services the authority to enforce or establish court orders when it receives a referral from a public assistance benefits recipient or through an application for our enforcement services. Under the federal rule, recipients seeking public assistance are required to participate and cooperate with the child support program and to share the cost to reduce the overall public assistance benefit. Upon a referral or application, if an order is already established by the court, child support services will begin to set up that order and begin enforcement actions. If no order is previously established, child support services will refer the case to establish paternity, establish a child support order or medical support order. Child support services does contract with contract attorneys, private attorneys throughout the state for those services to establish, modify, or seek civil contempt for non-payment of child support. Child support services also reviews cases for modification per request. Oh, I apologize, my nose is running. For the custodial parent or non-custodial parent when they request a modification through our agency. Under Idaho Code 56203C2, the Department of Health and Welfare is not authorized to provide services regarding, I apologize, services regarding visitation or custody unless it's authorized by the Title 4D program, which at this time we are not authorized to address visitation and custody. So the enforcement actions available to us, so only upon request for enforcement services through an application or benefits referral, the following enforcement remedies will occur. That includes income withholding orders to employers or the unemployment agency. These are automatic actions if the court order has the mandatory automatic and immediate wage withholding language in the order. Liens on real and personal properties. This occurs when the balance is 90 days of past due child support or $2,000, whichever is less. State and federal tax offsets. So we certify for state and federal taxes. This federal requirement is when $500 in past due child support is owed, that we would certify for federal taxes. We report to credit bureaus. We deny passports through the Federal Office of Child Support Enforcement. License suspension of drivers, recreation, or occupational licenses. This will occur when the balance is 90 days of past due support or $2,000, whichever is less. We are authorized to take financial data match, which will occur also when the balance is 90 days or $2,000 in past due child support. Civil contempt and federal prosecution. In federal prosecution cases, there must be an interstate component and owe at least $10,000 in past due child support. So our child support administrative funding, child support programs are funded through a combination of federal and state resources. The federal government provides matching funds for states and their child support enforcement programs. For federal funding, the federal government reimburses states 66% of their allowable child support expenditures. And there's incentive payments are also provided to states for efficient program operations. There is state funding. States contribute the remaining 34% general fund match to receive the federal contributions and to operate the child support program. Administrative costs are paid for by federal and general funds, a 34%, including case processing fees added to the child support debt. And then the authority granting Idaho child support, the authority through state statutes, we have the Code of Federal Regulations 45, Chapter 3. And then Idaho statutes, the department's authority is outlined in Idaho Code 56203A through 56203F. Child support is specifically addressed in Idaho Code 32706. Child support payments to be paid through the Department of Health and Welfare. And then the next Chapter 7 really outlines our enforcement remedies available to us as outlined by law. And then the Idaho Child Support, the Family Law Procedures Rule 120 outlines the child support guidelines specifically on how child support orders and the amounts are derived. So in closing, the child support services gets involved primarily when a court order has been determined and a legal determination for paternity, medical, and/or child support is established. Child support acts as a payment receiving agency and does not enforce until request for services is received through a benefits referral or an application for services. The enforcement remedies available to child support program are outlined under Idaho Code as referenced in the previous slide. And the Idaho Child Support does not have authority to address custody and visitation when establishing child support orders. So that concludes my presentation. I want to thank everyone for allowing me to be here today to discuss the history and the case processing of the child support program. Are there any questions for me?
Thank you, Ms. Haylett. We appreciate you being here and for that presentation. Committee, are there any questions that you have? Representative Scott?
Thank you, Madam Chair, and thank you so much for showing up to speak today. I'm curious, with the federal money, are we required to coordinate with the feds, and is there any incentives from the feds that come in for doing the service?
Ms. Haylett?
Madam Chair and Representative Scott, yes, there are some incentives for the child support enforcement program. And as far as cooperation, I would have to get back with you on that question. I'm fairly new to this role, so I've been in this role for 4 weeks. So I'm still learning some of the things. But as far as incentives, there are incentives available to states. Those incentives, there's 5 areas, which is establishing paternity, establishing child support orders, collections on current child support amounts, collections on past due child support amount, and cost effectiveness. So there's incentives available in those areas.
Follow-up, go ahead.
Thank you, Madam Chair. And ma'am, I'm curious if the parent that's paying child support, can the other parent, can the parent that's paying child support, can they look at the receipts? So like, or is it just like they give them the money and that's it? They can't see if they're recklessly spending the money or anything. It's just, it is what it is, and you guys just make sure it gets paid.
Ms. Haylett?
Representative Scott, Madam Chair, that's not something that the department has authority to get involved in. They could present those records to the court. It would be a private matter at that time to go back to the court if they felt the money was not being spent, but that's not something that the department or the child support services becomes involved in. We're solely enforcing the order that was already determined by the court and the specific dollar amount. So we enforce the specific amount, and if questions are being asked or needed, that would need to go back to the court.
Okay. Ms. Haylett, I have a question for you. So in regards to if there is a parent that has ordered to pay child support and they refuse to do so, or they're just not doing what the court has ordered, what is the process for that on your end? How do you go about making sure the parent pays? What's the process on that?
Okay. Yes, Madam Chair. So within our enforcement remedies, as the case goes along and as the case gets set up, depending where the case is, so automatic and immediate wage withholding. So we start with wage withholding to employers through Department of Labor interfaces. So if we have access to employers, a wage withholding is automatically sent. We do certified for state and federal tax offsets. Report to credit bureaus have liens on any real and personal property. If the non-paying parent is still, not in compliance with that court order, we look at in a license suspension action on driver's license, recreational licenses. There's a few enforcement remedies that we're able to take. If those still do not work, then we will refer it back for a contempt situation and bring the parties back to court and have the non-paying parent, explain to the court why payments are not being received.
Okay, and just a follow-up to that. So if you're doing garnishment of wages, is there a punishment to the employer if they do not comply with that?
Yes. There are, under Idaho code, there are punishment for employers if they do not pay. That is a separate action. The department does, on occasion, take those actions. Employers in Idaho have been very great to work with, and I don't see a lot of that in our state.
Okay. Thank you. All right.
Thank you.
Any other questions? I've not seen any. Thank you so much for being here and for your presentation on that. And good luck in your role as you learn more about it too. So thank you so much.
Thank you.
Okay, we are going to go ahead. Oh, we're doing pretty good actually. And we want to welcome Representative Gannon. He's joining us. Thank you for being here today. We are going to go ahead and move on to John Spalding. He's the lead deputy attorney general in the Health and Human Services Division. So, Mr. Spalding, thank you so much for being here, and go ahead and state your name for the record and then proceed.
Sure. My name is John Spalding. I'm a deputy attorney general assigned to the Department of Health and Welfare, and some of my coworkers would be upset if I didn't mention there are more than one leads. We're a big group. Okay. I work primarily on child welfare cases, and I've done that since 2019. In my current role, I spend most of my time advising central office employees in the child welfare and some other programs. But I've worked on child welfare cases both as a county deputy prosecutor in Canyon County and as a regional deputy attorney general in Region 3, which is the same as Judicial District 3. That would cover Canyon County, Gem County, all the way up through Adams and Owyhee. This morning, I planned tentatively to present on the following. The services and programs that make up Children, Youth, and Family Services, the function of the child welfare system, and in particular, how the department investigates child abuse, abandonment, and neglect, how private parties and courts and family law cases can get information from the department when they would like it, and then I'm happy to answer committee questions about the Central Registry if that's an issue on which you'd like me to answer questions. However, my goal today is to provide information that you'd like and need, and so I'm happy to reorganize or go in the order that you prefer, or just start with questions if that's better for you. But absent that, happy to start where you'd like.
You just go ahead and start, and if there's questions that pop up as we proceed, I can pause you and we'll take those, but yes, go ahead.
The Child, Youth, and Family Services is actually a broader part of the Department of Health and Welfare, and it includes both the child welfare system, but also things like navigation and 211. Those are services that link Idahoans to community and state resources. They might link you to a food stamps application. They might link you to other forms of assistance. They might link you to community services. The 211 line is actually a sort of one-stop shopping for people who need community resources, whether those be state, federal, or non-governmental resources. Turning to the child protection system, I'll start where the code section starts. The Idaho Child Protection System has a single unifying goal, and that goal is stated in Idaho Code Section 16-1601. It reads, "At all times, the health and safety of the children or of the child shall be the primary concern." The department aims to accomplish that goal by investigating reports thoroughly and professionally, by intervening where appropriate, and doing so in an appropriate manner, by providing safe and secure care for children as needed, and working with others, including courts, to make sure that constitutional and statutory rights that parents and other caregivers enjoy are protected. I want to start by explaining a feature of the child protection system, which is that, generally speaking, the child protection system is separate from the other court cases that may involve the same people and even the same events. So if a child is abused, any of the three cases may be opened at the same time, and each would function independently. If a child is abused, that may be a crime. That crime would be processed by law enforcement, the pleadings would be filed by prosecutors, and the case would go to magistrate or district court and be assigned to a judge who handles criminal matters. It might also result in a child custody case. That would be a civil case, the kinds that the magistrate who spoke before me presides over. There might also be a child protection case. Each of those cases would be different. Each of those cases would have different litigants, or could have different litigants. It would have different evidence, and there might be issues and facts that go between them, but by and large, those cases would be handled separately. As it pertains to child custody, if there's a pre-existing or new custody case arising from a divorce, the child protection case takes precedent under Idaho Code 16-1603, which is to say that if there's an existing custody case and it's going apace and people are filing pleadings and negotiating, the court is likely to hold that case on sort of a timeout status. It's usually called a bance, while the child protection case goes on. And the reason for that, I think, is that sometimes cases result in termination of parental rights, and then the need for your custody case sort of goes away. The parents no longer have rights to divvy up between the two of them. But also, sometimes a lot comes out during a child protection case, and also people get a lot of helpful treatment and opportunities to change how they parent as part of a child protection case. And so generally speaking, while the child protection case is open, the child custody case in divorce court is not closed, but it's also in a sort of inactive staying pattern. All child protection cases begin with an investigation, and nearly all of those begin with a call to the department's intake line. That line is staffed 24/7, and if you're interested, the hotline for it is 855-552-KIDS. That exists for a lot of reasons, some of which are practical, some of which are legal. The legal one being that Idaho Code Section 16-1605 generally indicates that the Department of Health and Welfare is the informational clearinghouse for reports of child abuse, abandonment, and neglect. So a person may make a report directly to that kid's line. The statute also allows them to make a report indirectly by contacting law enforcement who contact that line. In fiscal year 2024, there were 24,365 referrals made to the intake line. Those calls came from parents, family members, teachers, clergy, law enforcement, medical providers, concerned communicators, and a number of legislators. From there, the case is assigned for investigation or screened for investigation. Some cases are screened out. That occurs for a variety of reasons. But in fiscal year 2024, nearly 10,000 cases were assigned for investigation. That's more than 25 new investigations every day, with the caveat that some of those are multiple reports on the same family. As cases are assigned, they are prioritized and given a timeline. The most serious cases require that work begin immediately. That doesn't mean that the person leaves their office immediately and gets in a car, but it does mean that work begins immediately. That's often calling law enforcement, sometimes because the case involves mutual concerns where the abuse is likely to be criminal if proven, but sometimes it's also to ensure worker safety. Examples of items that would be assigned to that top tier include human trafficking, life-threatening injuries, sexual abuse of a child, unless something else keeps the child safe, like an arrest. The next tier of cases is sort of one lower. It requires that a worker respond within 24 hours and see a child within 48 hours. These include cases like physical abuse of a child with disabilities. It includes many neglect cases. And the lowest tier of assigned cases involve things like unsafe housing or insufficient supervision. For those cases, response must begin within 72 hours and the child has to be seen within 5 days. Of those classifications, items classified in Tier 1 and Tier 2 must be reported to law enforcement. Items in that third tier may be reported to law enforcement, and often are, if the worker suspects that the allegations, if proven true, would amount to a crime. I've mentioned law enforcement a couple times, and that's been on purpose because these investigations are often multidisciplinary. They often involve different government agencies, and they sometimes involve non-government agencies like hospitals and medical providers. Just by way of example, law enforcement is regularly involved for a couple reasons. The first is that they have direct interest in prosecuting crimes. The second is that they have a different set of investigatory tools than the Department of Health and Welfare does. In my prior time, I was one of the special victims prosecutors in Canyon County, and the police and warrants have a variety of tools to investigate crimes that the Department of Health and Welfare doesn't. For example, it is routine in sexual abuse cases for law enforcement to obtain search warrants to search digital devices or to use other tools to engage in that sort of investigation. Those are not tools the department has or can use. And so it's often really important for the different agencies and different bodies to use the tools they have and the expertise they have to sort of come to a shared understanding of facts. After a case is assigned a level of priority, so that top level, mid-level, and bottom level, the case is transferred internally in the department from intake to safety assessment. The end result of that safety assessment is going to be a document titled Comprehensive Safety Assessment, and I'll sort of walk through what components of that. The other end product is usually a decision about what next steps the department is going to recommend. This is the part where I pause and say the department has no authority on its own to remove a child. Children can generally only be removed by a law enforcement officer or by an order of a court. The department on its own lacks the authority to go pull a child into care. And so part of that comprehensive safety assessment is deciding which path they're inclined to take.
Okay. Let me pause for just a minute. Representative Ehart has a question. Go ahead, Representative.
Thank you, Madam Chairman. Just a clarifying question before you go on. So you just said that your department has no means of removing a child. It's generally law enforcement. And then you said, I think you said law enforcement or a court order, but isn't it still law enforcement? Who besides law enforcement can remove a child?
Sure.
Mr. Spalding?
I'll move ahead just a little bit and answer your question. There are a number of more specific, rarely used procedures, so I'm going to talk about the three big ones. The first one is law enforcement can declare a child at risk of imminent danger. There has to be a sort of imminency requirement there, and they do a couple of things when they make that removal. They first take physical temporary custody of the child. They provide form paperwork filled out to parents or guardians, and then they provide notice to either a deputy attorney general or a prosecutor, which would cause that person to initiate the filing of a child protection case. The second way a child can come into foster care is called the endorsement process. In that case, the department or law enforcement completes an affidavit, and a prosecutor or deputy attorney general would complete a petition for either removal or for the initiation of a child protection case without a removal. If the court finds that there's a legal basis for the case to be opened and or removal, then the court would enter that order.
Madam Chairman?
What?
So then clarifying, so then if the court finds that to be appropriate and the child should be removed, who removes the child?
Go ahead.
Madam Chair, Representative Ehart, it depends. Often law enforcement is involved in the removal. Sometimes they're not. It depends on what the parents are sometimes willing to do and sometimes where the child can be found. Sometimes they're already on a safety plan with a third party, and then the department might just call people and make arrangements to go pick a child up. Sometimes that's not safe or appropriate, and law enforcement has to be involved. But it's not necessarily the case that every order of removal is done forcibly by law enforcement. They're usually there to do paperwork, however.
Quick follow-up.
Yes, go ahead.
So I guess then in my mind's eye, I think that just explained it, because I guess I was kind of wondering if a child was to be removed, how would a parent know that such a thing was lawful? Usually, if somebody shows up in a uniform, even though that doesn't always make it lawful, but if it is lawful, we would assume that. So what you're saying is that typically if it wasn't, that it's because there had been ongoing communication with the courts to either directly to the parent or somebody who's representing the parent. I'm assuming that.
Yeah, the order of removal goes to law enforcement, is directed to law enforcement, so they're almost always there. But sometimes they're there sort of to be helpful rather than really doing it. The department works it out practically to help the child come into care. They're always or almost always involved. Does that answer your question? Yeah.
Go ahead, Mr. Spalding.
Sure. The third way that children generally come into care is an expansion from juvenile justice cases. That's a case where a court that would oversee sort of juvenile crimes concludes that a child protection case should be initiated, and the juvenile court in that case has the authority to initiate that case. And once again, that court can issue an order of removal or not. There are a couple of exceptions, like safe havens, and as of Tuesday of last week, orders to prevent removal, but those are less common. The department's process for investigating child abuse, abandonment, and neglect generally involves them using a guided decision-making tool. The facts about that are available on the department's website and also in the Child Protection Manual. I believe the manual is still pulled down for revisions, but it should be back online. That's a publication of the Idaho Supreme Court. And the department uses tools that compare a list of risks and also a list of factors about those risks. Some of the things are like severity, frequency, items like that. If a child is removed, shelter care happens within 2 business days. At that hearing, the government generally has to prove that the child has been abused, abandoned, or neglected, or that the child's been subjected to an unstable home environment, that it's in the best interest of the child to remain in care until the next hearing, and a few other factors that are jurisdictional, like, is this the right county? Has a petition been filed? And some interest and factors about reasonable efforts made by the department or whether those could not be made. That hearing has a lower burden of proof. The burden there is reasonable cause to believe, and the rules of evidence do not apply at that hearing. At that hearing, or usually before, parents or guardians are appointed an attorney at state expense. They usually are appointed before the hearing. Sometimes they're appointed closer in time to the hearing, but they appear at that hearing and represent the parent or guardian at that hearing. Likewise, the guardian ad litem is appointed counsel. Sometimes that's a state expense, sometimes that's a volunteer. If the state prevails, the child usually remains in care and the next substantive hearing is set. If the parent prevails, the child is usually returned home and the case may be dismissed. The majority of cases are resolved by agreement. Most shelter care cases are not contested hearings. Most shelter care cases are ones where parents in the department and the lawyers in the room agree that it's appropriate to keep the case open and to keep the children in temporary foster care until the next substantive hearing. And so the majority of kids remain in care at that hearing for that reason. The next hearing, or the next major hearing, is an adjudicatory hearing. That has most of the same elements as that shelter care hearing, with a couple of changes. The first is that there's a substantive difference. At the adjudicatory hearing, the court's going to make a decision about where the child should be placed and how they should be placed. And the big two options are foster care and a status called protective supervision, where the children would return home subject to the authority and with a case plan. The other difference is procedural. There are discovery obligations for an adjudicatory. The burden of proof is higher. It's the preponderance of evidence burden of proof, which is the same standard that would exist in most civil cases. And the formal rules of evidence do apply. Once again, if the parents prevail, the case is likely to be dismissed and the child is likely to be returned home. If not, the case would go from there, from the adjudicatory hearing, to a case planning process. Once again, most cases don't go to contested hearings. In most cases, there's an agreement between parents and the government and the guardian ad litem about what should happen with the case. And I would say most children remain in care at the adjudicatory hearing and after the adjudicatory hearing. The next step after that is usually case planning. At case planning, the court will impose specific tasks for parents and the department to complete, and then the court will enter a court order directing them to complete it. Some common examples are the department, for example, being required to make a referral and pay for services, sometimes things like substance abuse or mental health treatment, and the parents will often be required to attend and complete those classes or treatment. After that, the case proceeds. Most cases result in children eventually returning home. The last numbers I reviewed indicated that 2/3 of kids in Idaho who enter foster care eventually return home to at least one parent. But in the remainder, 1/3 of cases, any of the following might occur. First, the child might be placed in a guardianship. That's often with a family member. Second, some children age out of foster care. Children can age out at 18 if they're uninterested in extended foster care or ineligible for extended foster care, or will age out at 23 if they accept extended foster care and haven't left the system for some reason before that. And for other children, parental rights are terminated, usually with the goal of them being adopted by new parents who apply and are selected by the department. Here too, however, I would note that many adoptive parents are family members, friends of family, or other people who have pre-existing connections with the children. I want to spend a little bit of time talking about how family courts obtain information gathered by the child welfare system, because I think that's of special interest to this committee. And I'm going to run through more or less 3.5 processes, and I'll go through each one of them in turn. The first one is parents often have direct information that is exactly the same as what the department have, and they don't really need to do a lot of steps to have the information they already have. Secondly, the department processes a lot of public records requests, and a lot of those relate to the child welfare system. 3, the department responds to subpoenas. And 4, as Judge Scow talked about earlier, there's a procedure for the court to order IDHW to do an investigation. The first one is sort of the half one. That's that parents often know information. Sometimes they're reporting party, sometimes they're directly observed abuse. In those cases, they don't often ask for the department's information because they are the first and best witnesses to it. They still have the availability of asking the department for records or paper records or for an in-person witness, but they often don't take advantage of it because it's not helpful to them or to the court. Second, Idaho Code Section 74102 outlines some of the public records process. That statute creates a right to examine records and a presumption that all records are public records, or all government records are public records. That would include almost every single paper drafted by IDHW program staff. Now, the disclosure of those records is limited, but it tends to be limited in a way that doesn't affect parents in custody cases. So, for example, Idaho Code Section 74105.7 limits the release of child protection investigation paperwork, and court rules often limit the release of certain records that are also court records. And finally, lots of records are covered by federal privacy laws like HIPAA, because often child abuse cases will involve things like medical testing or even just medical treatment. However, almost all of those give way to a parent who signs a release or a parent who makes a request. The Idaho Public Records Act gives people expansive access to their records, and that will generally overrule most exceptions in the Public Records Act. Likewise, HIPAA and federal privacy laws generally authorize parents to consent to the release of records about themselves and their children. And so generally speaking, if a person requests records about them or their children through the public records request, they get back a very lightly redacted copy of all the department records. There are also some features of that program that are generally desirable. The public record system is fast. You generally have to respond within 3 days or 10 days if you request an extension. It's also generally very inexpensive. For Idaho residents, the first 2 hours and 100 pages are free. I would say the overwhelming majority of requests for people's own records are less than 100 pages and far less than 2 hours. And if it's close, the department is usually not particularly inclined to charge for the incremental amount, especially when people are requesting their own records. And this is not a small or rarely used process. The department leads the state in processing public records. Last year, my client informed me that the department processed 5,000 public records requests. I was unable to get the numerical breakdown of where each of those went. But as a person who handles a fair amount of them, I can tell you that I would be astonished if at least 1,000 of them were not records for child, or not requests for child welfare records. And I would be unsurprised to find out that it was at or more than half of them. The third way people get records is through subpoenas. Both the Idaho Rules of Civil Procedure and the Idaho Rules of Family Law Procedure authorize the issue of a third-party subpoena. The most pertinent rules are Family Law Rule 409 and Civil Rule 45. Both authorize two different kinds of subpoenas. Both authorize subpoenas for in-person testimony, and both rules authorize subpoenas for the production of records. Program staff are regularly subpoenaed to testify in civil cases. They most often testify in civil protection order cases and in divorce custody cases. They also process a very large volume of subpoenas for records of family cases. Once again, I don't have a numerical breakdown of that, but I do see the open subpoenas every time I go into process subpoenas or public records. And I would say that at any given time, 50% or more of the subpoenas submitted to the department are requests for child welfare records, and of those, most are submitted in cases where people are involved in a divorce custody case. The last way people get records from the department in a child custody case is through the court-ordered investigation process. Judge Gao talked about that a little bit earlier, and I would just like to touch upon a couple of provisions of that code section and also how the department goes about fulfilling its legal obligations. That code section has existed since 1995. It's 32717C, and as the judge described, it is mandatory. Whenever in a divorce proceeding or on a request for modification in a divorce proceeding, there's an allegation of abuse or child sexual abuse, the court is obligated to order the investigation be done by the Department of Health and Welfare. And then he talked about some of the procedural components of that, including the 30-day time period. I'd like to provide you a little bit more information about what goes into that report, because I think most people most of the time don't see those unless you're actively involved in being a litigant in family law cases. The top of the report is usually the information you'd expect about the family: names, addresses, birthdates, genders, that kind of information. It's followed by a comprehensive review of the department's child welfare involvement with the family. So they don't just investigate whatever the prior concern are. They will list out all the other times that they have had referrals or investigated that family, which gives the court the opportunity to have a lot more context about at least the concerns that have been brought up and at least the department's resolution of those concerns. Next, the department reviews collateral facts. That includes medical records where available and where they're relevant. It might also include reviews of court records. The department usually pays special attention to criminal convictions, protection orders, no contact orders, things like that. Next is a discussion of family functioning and the parenting capacity of each caregiver. The department might include an assessment of mental health diagnoses and drug use. I don't believe the department makes a diagnosis, but it will review previously made diagnoses by other mental health professionals. It usually includes financial information about how the family meets its financial needs. And the department has places for the department staffer to describe parenting practices, disciplinary practices, and protective capacities. Similar information appears for children, including the child's physical health, mental health, and any substance abuse by the child.
Mr. Spalding, can we pause for a minute? Representative Uhart has a question. Thank you.
Sorry, thank you, Madam Chair. I want to back up. So going back to 32717C, and as I was briefly looking at that, and a question I'd asked earlier, it does seem that, and the judge answered it well, that you'll have a family, they've had a relationship, there's never been an allegation of abuse. Now there's an allegation, you're just about to have that hearing with the judge, and boom, there's an allegation of abuse. And so, as it states in here, nothing can happen until 30 days and it's checked out, right? Is there any directive if that allegation of abuse is proved to be false? Because a false allegation of abuse is pretty serious, and especially when oftentimes you're the person who has the child and may be making that allegation of abuse is preventing the person from seeing the kids, and now it's 30 days and it may be another 30 days. You understand what I'm saying there. Is there any repercussion for a false allegation?
Mr. Spalding.
Madam Chair, Representative Ehart, yes, with a substantial number of caveats. So first, untrue statements can sometimes be punished as perjury depending on how they are made. Generally, you're required to either file an affidavit, make a sworn statement, or accept the penalties of perjury before that risk of being liable for perjury can attach. Perjury charges are not common. In my time as a prosecutor, and I worked in a prosecuting office for 5 years, I don't recall one. And I worked in Canyon County, which is a big county that handles tens or hundreds of thousands of criminal cases in the time I was there. I'm not representing there were none. I'm just representing that that is not how most prosecutors spend their time. Yeah. There is specific liability for a false report. Let me grab the code section for you. In the Child Protection Act, there is a relatively recently updated provision for reporting in bad faith. That generally requires that the report be made in a particular manner, and I don't have at my fingertips whether or not a report sort of made on the record but offhandedly to a judge in a divorce case would count. My recollection is that the reporting requirement is specific to reporting to the department rather than giving information to a judge. But that's another possible route of liability. And the third is civil liability for defamation, slander, or libel, depending on how you made it. Although I would say that there are often litigation privileges that may change the scope of a person's liability for accusing a person of a crime in court versus in the public. So those are the kinds of liability that might attach. Two options for criminal liability. The first one is perjury, but the statement is unlikely to be made under penalty of perjury unless they're sworn in or put it in an affidavit. A false report, if it's made to the Department of Health and Welfare through that intake line, or civil remedies for defamation. Although, once again, those are not particularly commonly filed actions, as far as I can know.
You have a follow-up? No, that's okay. Okay. Representative Gannon?
Oh, thank you, Madam Chairman. I had a question on when a person who's accused or being investigated has a right to an attorney, and whether a person who cannot afford an attorney would have a right to a public defender.
Mr. Spalding?
This session, there is legislation on that. I don't know what the result of that legislation would be. It involves the state public defender who's currently handling those cases. And so I don't have a good answer for that. I can tell you how it's worked until that legislation affects things. As of now, upon the filing of a petition, in most counties most of the time, the deputy attorney general or prosecutor filing that will include a packet of other materials along with the petition. In there is a motion for the appointment of counsel. Counsel is usually appointed at that time by the judge, so they'll sign the petition if they sign the petition, and then sign the motion for the appointment of counsel. My understanding, and don't quote me on this, but my understanding is that order goes to the state public defender, and they make an assignment of counsel. The part that I can tell you is that their attorney, whether that be the state public defender, employee, or conflict counsel, appears at the shelter care. During COVID, that was sometimes more difficult, and immediately after the changeover from the county to the state public defender system, there were some hiccups with making sure there were attorneys at every single shelter care, but by and large, that is the overwhelmingly common practice.
Representative Scott?
Thank you, Ms. Chairman and Mr. Spalding. When there's a custody case going on in the family courts, does the health and welfare do anything differently when it's looking into child safety issues? I mean, is there any consideration or is it just treated like every other one?
Mr. Spalding?
Madam Chair, Ms. Scott, I don't think there's any particular legal provision that says if there's a custody case, do X, Y, and Z differently. I think sometimes it affects how a case is viewed, mostly contextually. So for example, if you have a ton of cases where a person has reported abuse, you've investigated and you've found it, and you've concluded it's unfounded, the custody case may be an explanation for why that's occurred, for example. But I would say there's no direct legal effect of there being a case, with some exceptions. So here's a big one. If you have a custody order that exists from another state, let's say you lived in Nevada and you got divorced in Nevada, and then you moved to Idaho and children came within the purview of the Child Protection Act. There's a statute that governs sort of which court gets that, called the UCCJEA, which is the, I wrote it down because I never remember what that acronym stands for, the Uniform Child Custody Jurisdiction and Enforcement Act. So in that case, the fact that there's a prior divorce case would matter a lot because it may determine which judge hears that case and in which state that case is heard. But generally, the department is focused, pretty laser focused on child safety, and children can be safe and they can be unsafe when a child custody case is open.
Okay, thank you. Go ahead.
Just my final note on the ways litigants and also parents can get information from the department is just noting some of the practical differences. Public records requests are short, quick, and easy. Most of them, most of the time, are processed by the department with probably less than an hour of hands-on time. That's not to say all of them. Sometimes we get public records requests for hundreds, thousands, tens of thousands, and occasionally millions of documents. But most of the time in this realm are processed relatively quickly, and the department, by and large, does a really good job of making sure that they arrive within that 10-day period. Likewise, subpoenas are processed by record staff, and the processing time for those is usually short. We usually meet our deadline of 30 days. That's in most subpoenas. The court-ordered investigation process is time-intensive. It often involves safety assessment staff doing full work days or full work weeks of work on any particular case. It's important work. Those are reports from a judge that a child may be abused, abandoned, or neglected. And because of that, because of the nature and of who is reporting and the nature of what is reporting, they are often relatively highly prioritized and often have very serious allegations involved. And so it's important work that the department is happy to do, but it is a fairly substantial amount of work.
Representative Ehart, you have a question? Go ahead.
Yeah, I'll try to make this really quick, and you can, so just if abuse is reported from anyone on anything, basically is a parent that's being accused of that abuse, are they always made aware that they've just been accused of the abuse? Is there a means of keeping that sort of information from a parent?
Mr. Spalding.
Madam Chair, Representative Ehart, generally, the department is required to provide parents of notice of the fact that there is an investigation and the disposition of that investigation. Sometimes law enforcement will ask that, in particular, sex offenders or alleged sex offenders are interviewed by the department first. And there the department might wait and let them be interviewed by the department or by law enforcement before the department does it. And then the department would meet with them after and provide them notices and paperwork after.
Quick follow-up. And then, Madam Chairman, sir, if that, whatever the findings of the investigation, is that information shared with the offending parent?
Mr. Spalding.
Madam Co-Chair, Representative Ehart, are you talking about the court-ordered investigation process or a general call comes into child welfare and they investigate?
Clarification, Representative Ehart.
No, thanks, Madam Chair. No, not just a call. I mean, maybe that, but I'm talking more of court order where there's, been an actual investigation. Is that information then sent and shared with the parent that's been investigated?
Mr. Spalding.
My understanding is that the order goes to the court. I'm not 100% certain what they do with it afterwards because that's past my sort of stage in the process. Being involved in the process, I can tell you that they, in the vast majority of cases, they get a copy of it. I would be astonished if it is regularly surprised that they've been investigated. The investigation usually includes them being called, them being asked for other people who might know about the situation so that the department can call them. And usually the court has ordered on the record that an investigation occurred. So it would be remarkable for it to be a surprising finding unless they just aren't there in court. And I don't know how often that happens.
Okay. Mr. Spalding, do we have, on our statutes, do we have a definition for parental alienation that you're aware of? And if so, can you tell us what that definition is?
I'm not, Madam Chair, I'm not aware of a definition of parental alienation in the Child Protection Act or Child Protective Act or in the termination of parental rights statutes. That would not trigger a case under the Child Protection Act unless there were some other features. So if you alienated a parent and it amounted to neglect, or you alienated a parent and it amounted to physical abuse as defined under the statute, or sexual abuse as it's defined under the statute, or some other way, it's possible that that additional fact could cause a child to come within the purview of the Child Protective Act. I don't practice family law. I took one CLE that was required by the bar. I think that was in 2013. So it would be irresponsible of me to answer the question about what the statutes may say about parental alienation for the purposes of divorce and custody.
Okay, thank you. See any other questions on here? And is there anything, Mr. Spalding, that you can think of that you would like to leave the committee as far as anything that you can see that maybe needs to be addressed on your end that we could facilitate?
I can say this, that The department generally has an open door. I use it if I think there's a thing that could be or should be changed. I haven't had a ton of time to think about these issues. I came on relatively short notice, and I'm happy to be here. But I may run some ideas I have by the department to make sure that a thing I suggest isn't wildly impracticable or a bad idea for any number of other reasons.
Oh, very wise. Thank you so much. All right. I don't see any other questions, so thank you, Mr. Spalding, for you being here today. We appreciate it.
Thank you.
All right. Committee, we are going to go ahead and break for lunch. We want to thank everyone that was here. And so those that are visiting with us, we're going to break for lunch. We'll be back here at 12:45 to continue on with the task force. And so we will go ahead and adjourn until that time. Okay. All right. Thank you so much. We are going to re-adjourn. We're not done yet. What am I saying? No, thank you. Welcome back to everyone. And we are going to go ahead and get started. We're doing really good staying on task for our time, so we'll continue that. We have next with us Ada County Board of Commissioner member of the Magistrate Commission 4 Judicial District, Rod Beck, is here with us. And so we're going to go ahead and start with you, Mr. Beck, if you want to take the podium and just go ahead and introduce yourself, and then you can proceed. We're so glad to see you. Thanks for being here.
Well, it's nice to be here with you.
And then you'll just need to turn on your microphone down at the bottom there. There's a little slide thing right there on the bottom of it. Oh, they'll get it for you. There you go.
Okay, we're on now.
We are on. Yes, that's right.
Well, I emulate my brother. He speaks not quite as loud as me.
Welcome, Mr. Beck. Go ahead and state your name for the record.
Well, thank you. Rod Beck. I'm the chairman of the Ada County Commission, and as such, I'm on the 4th Judicial District Magistrate Commission. I have a little bit of background. I was in the Senate for 6 years or so. 7. And I've run the Idaho Housing Agency for a while. And since 2021, I've been on the Board of Commissioners of the Ada County Commission. And I'm chairman of the board, been there since. And I got a call saying, you ought to come and tell us about the Magistrate Commission. So I actually made a copy of the Magistrate. This is the current Magistrate Commission for 4th Judicial District. And as you see, it's got Judge Hippler as the chairman of the commission, and it's got the commissioners, because we have there's 4 counties, Ada, Valley, Elmore, and Boise County. So each one of those are chairmen of their various commissions or designee. In this case, they're all chairmen. And then you get down to the attorneys, which I think is kind of interesting, because the Bar Association, a private organization, makes these appointments. Did you know that? They make these appointments, and then the governor makes the balance, or some of these appointments. There's supposed to be 3, actually from 3 cities, and they pick the city with 10,000 or more, and that's John Evans, and then there's 1 vacant, and then the mayor of Glens Ferry, and they're picked by the governor, and then there's 2 electors that are just chosen at random that the governor picks. And then the magistrate judge picks the last 2, the clerk of the court and another magistrate judge is on the magistrate commission. I made next for you just so you get an idea what it takes. This is the schedule of the next vacancy that's coming up. When it starts, it has to be advertised by the Supreme Court, and this gives the vacancies how it works. And we actually have the final interviews on September 12th, so it's a long process. They take applications, and this is one of the things that I think is kind of weird, is they allow members of the bar to anonymously attack the applicants. And that's what they do. They attack them anonymously, and I think that's wrong myself. They don't get to respond. They don't even know what the comments are, but we get them all the comments that they make. And I'm going, well, that's kind of weird. Because they want comments from the legal profession. And, but then the comments are made anonymously. Then my next page, I included, there's 30 magistrates in the 4th Judicial District. And I have a list of which area they're assigned, because they're assigned by the administrative district judge as to whether they're going to do family law, or whether they're going to do criminal law, or whether they're going to do probate. And if you notice, this is the list of which judge are assigned to which court. And as you see, there's quite a few on the family court. Family court child protection, that's the one with the most. And they do all the divorces and child protections, things like that. Then there's a criminal law, and that's for the misdemeanors and the traffic court. And by the way, that's something you folks ought to look at. Ada County has over $44 million of unpaid fines. You know why? Because there's no way to collect it. It used to be. What's that? I'm just saying. There's $44 million that hasn't been paid. And it used to be, if you didn't pay your traffic fine, you'd lose your driver's license. But the legislature changed that a few years ago, so now there's no remedy. Seriously. And yeah, it's a different. But I also included the law that has how the Magistrates Commission is comprised, who makes the appointments, and if the appointments they're various because the chairman of each county commission in the Magistrate Commission can either be on the commission or appoint a member of his or her board to be on the commission. And then but when we do that, when the commission's made up and when there's an application, we have no idea what court they're going to serve on because that's a function of the administrative district judge. We don't know if they're going to be assigned to a family court, if they're going to be assigned to a criminal court or probate. We don't know that. We just interview, and that's another difference is between the magistrate court and the district judge court. We don't interview every applicant. For the judicial council, when there's an opening for a district judge or for the Supreme Court, they interview every applicant. The Magistrate Commission does not interview every applicant. We take a poll, which I don't really agree with the way they do it, but they do it. They have a poll of we get 14 or 15 applicants, and all the Magistrate Commission will look at all the applicants and do a vote of which one we think we ought to interview, and then the administrative district judge, he ranks them. If I say this one's one, then that person gets 4 points. If I say I want this one for the second position, he gets 3, 2, 1, and then they add up the score, and then we decide whether we're going to interview 4 or 5, depending on how many applicants are there, and if we're filling one position or 2 positions. And the number of magistrates are determined by the legislature. Now, each magistrate or each district judge, administrative district judge, if they decide that if they think they need another magistrate judge, they have to go get the Supreme Court to approve it. Say, yeah, we'll authorize you to have a judge. Then they have to go to the county commission and get us to approve it. Once they've have those 2 approvals, then it's brought to the legislature, and the legislature gives the final say on whether there's going to be an additional judge or not, additional magistrate judge. So anyway, I don't think I have any more for you. You wanted me to give you a little background on the Magistrate Commission in the 4th Judicial District. So unless you have any questions, I think I've given you enough information if you want to look through the statutes there.
Thank you, Chairman Beck. We appreciate that overview. Representative Ehart has a question for you.
Sure. Thanks, Madam Chairman and Commissioner Beck. So you've given us kind of the, overall, what role, I mean, I think it was our understanding, and there's a lot I can conflate, that you might have review of judges on this commission. Is that something you do on a decision if it's appealed, or is that not? Do I have things conflated?
The Magistrate Commission, when they're first appointed, they have about a 6-month probationary period. At that time, the Magistrate Commission can review them. There's been one, not at my time, but in time past, where they've said, you didn't do a very good job, and they booted him. But it's only after the first 6 months. After that, I don't know how we've never had anything beyond that, because there's turnover in the magistrate commission, because it's the lowest court, and so some of them move on. They want to go to be a district judge, if you will. Sure. And because they get paid a little bit more, I guess. I'm not sure but we have never had any disciplinary actions in my term.
So follow up?
Follow up.
So if you've had the authority to review at 6 months, and now I grant that you've never done that, why do you think, I mean, of course we know it's because they're probably new, and that's why we're reviewing it, trying to catch it. Do you think there'd be any logistics to being able to extend that authority, so there'd be the ability to review if necessary? Because if everything had to go to the Supreme Court to review, it kind of seems like this is something you're over anyway.
Mr. Beck?
Yes, Madam Chairman, Representative Earhart, I do think there ought to be more review. And it's by the way, and I'm sure you all get the same thing. Every election, the biggest question I get from individuals is, what do I do about these judges?
Right.
Because the magistrate judges are supposed to be elected, but it's a retention vote. It's not how good of a job they do. It's just a retention vote. Should we keep this judge? And there's really no way for anybody to judge on that. Now, I may have a little better way to judge it, because I've met a lot of them that have been through the magistrate commission. So yeah, I think there should be a way, I think, to actually.
Sure. One more follow up on that,
Mm-hmm.
Madam Chairman, Mr. Beck, Commissioner Beck. To your knowledge, again, knowing you haven't been through this, if a magistrate judge had been reviewed in the first 6 months, speaking of the elections, is that information, or do you know if that information is then available to the public, that there's been a review and what that review might have said?
Mr. Beck?
Well, that I don't know, because I've not seen that. I do know that that the magistrate commission meetings are open to the public, and any of the documents and so forth. Now, what's not open to the public is when we deliberate on the candidates. But anybody can come in and listen to the interviews and so forth and get the responses. But
sure, but that's follow up on that. That's Madam Chairman, Mr. Beck. That's definitely not the same as. One of the interesting things I think a lot of us had just, in this whole process, especially since kids are involved and since families are involved, in Idaho as a family state, I think we're held accountable. I think everyone should be held accountable. And so in my mind's eye, I'm just trying to figure out, how do we hold all of us accountable?
Well, magistrate judges, in my time, years ago, magistrate judges were elected just like district judges. But then anybody could run be a magistrate court. In fact, I remember in my days, I grew up in Archer. You know where Archer is?
Yeah.
I grew up in Archer. My neighbor, who was a farmer, was a magistrate judge, because he ran for it, and and the people, they voted on whether to put this guy in on as judge. Well, they changed it a number of years later. That's when they come up with this magistrate commission thing and the retention vote. The legislature changed it, and I think it would be appropriate to have the magistrates just run just like a district judge.
Oh, wait, clarification.
Clarification, yeah, go ahead.
So you're saying, Mr. Beck, your friend next door was a farmer, not a lawyer?
Exactly.
Okay, interesting.
Well, and it wasn't next door, I just threw the field.
Oh, you're right.
So we had adjacent properties together. Yeah, and he was a judge, and I actually appeared in front of him once or twice. In fact, we even had a blind justice up there, Judge Forbush. He was blind, and he was a judge in Madison County. Yeah, yeah. So I think it's. I know the lawyers wouldn't like that, but you can be on the magistrate commission. You can be a magistrate judge without being a lawyer, but then you have to get through the magistrate commission, and lawyers appoint two people. The governor appoints a bunch of people. It's difficult to get through the magistrate commission unless you're a lawyer. But I think it would be. I didn't have any problem with it when I was a kid, and I still don't see any problem with it. The magistrate Commission, they don't write long opinions because they deal with small claims, they deal with divorces, and they deal with misdemeanors and any civil action less than $10,000. So there's a between the $5,000 of small claims and $10,000, it's only a small area that they can actually deal with civil matters. And so what they do when they have civil matters, they have other lawyers that write their opinions. I mean, they don't write a lot of opinions. District judges, on the other hand, they do. They write opinions.
Any other questions? I'm seeing none. Thank you so much, Mr. Beck, for being here with us today.
Well, thank
for
you.
That explanation.
If you notice, by the way, just this one final thing. This is not, if you notice, Sandra Barrios, that's her name. She is the trial court administrator. She is a state employee. The administrative district judge is a state employee, okay? And all these judges are state, if you're a judge on here, you're a state employee. But the county provides all the clerks for them. And so when you appoint a new judge, you're asking the counties to find a way to pay for all the new clerks out of our property tax.
Interesting.
Well, that's fine. That's fine. Anyway, thank you very much.
Thank you, Mr. Beck. Appreciate it. Okay, the next one we have is Dr. Brandy Lee that is with us today, and she's going to be talking about the psychology and family law. So welcome, Ms. Lee. We appreciate you being here. Go ahead and state your name for the record, and then go ahead and proceed.
Thank you so much for having me. My name is Bandy Lee. I am a forensic psychiatrist and violence expert from New York City. What I have to say will be stark, but I've seen a lot in my 25 years of experience being an expert witness for the courts, mostly criminal and civil courts, about 50 of which have been in family court across 22 states. I'm also president of the World Mental Health Coalition and co-founder of the Violence Prevention Institute. I was a research fellow of the National Institute of Mental Health and taught at Yale Law School and Yale School of Medicine for 17 years before recently joining the Harvard program in psychiatry and the law. In 2007, I co-authored the chapter on violence against children for the UN Secretary General, and have also authored other violence prevention documents. I'm a recipient of the National Research Service Award and author of the textbook Violence, as well as of over 100 scientific articles and chapters, mostly on violence prevention. For clinical practice, I work in maximum security prisons and specialize in treating violent offenders. When I became aware of the situation in family courts, I had had 2 decades of serving as an expert witness in criminal and civil courts. I may never have learned about them, but for my sister's divorce in Bergen County, New Jersey. Since family courts, as a rule, do not like qualified experts, especially independent experts. None of my previous experiences prepared me for what I was to find in family courts. Yale Law School's Robert Cover said, "Interpretations in law constitute justifications for violence. Nowhere does this seem truer than in family court, and the application more arbitrary, unjust, and unnecessary." Family court judges were granted almost unlimited discretion with the law so that they might exercise benevolence. But without transparency and accountability, their courtrooms have become veritable centers of human rights violations. Much like the prison system I have studied, which is another secret institution that conducts its affairs behind concrete walls with little oversight, brutality and violence flourish in the family court system behind court seals and judicial immunity. I would suggest that the combination of near unlimited discretion behind closed doors and immunity are a dangerous mix. It must be noted how prevalent family violence is. 1 in 2.5 women and 1 in 4 men experience physical violence from an intimate partner in their lifetime. 1 in 4 children experience child abuse or neglect in their lifetime. Over half of female homicide victims are killed by current or former male intimate partner, and more children die at the hands of their parents than any other relationship. It is therefore unsurprising that a vast majority of contested custody cases are actually family violence cases. And they involve some of the most dangerous individuals our society produces. To deny, or worse, to exploit family violence for profit can therefore be very dangerous, even deadly. Around 75% of fathers who fight over custody in family court abuse their children. Many go on to kill, such that almost 1 in 8 of the nation's child murders by parent could be reduced if family courts did not have a role. This can only be an undercount, as routine record concealment makes it virtually impossible to track the true numbers of child murders family courts facilitate. For every child murder, there are at least as many child suicides, and for every death, close to 100 children are injured to the point of needing medical care. Family courts label these cases as high conflict, but the actual situation is usually one-sided, with a criminally violent party using this alternative court not only to escape prosecution, but to frame the innocent victim. Having treated violent offenders in maximum security prisons as a specialty, I can tell you this is a perpetrator's dream come true. So you can imagine how violent individuals congregate in family court. Indeed, by circumventing due process and placing the force of the law behind family violence, which brings in revenue, family courts have become centers where violent criminals can darvo, which in psychological parlance means deny, attack, and reverse victim and offender. How does this happen? First, if child abuse is alleged or suspected, custody is transferred, sometimes immediately, to the abuser. According to some studies, this happens about 3/4 of the time, but in my experience, it has happened 98% of the time. I will use my sister as an example, but the methods are astonishingly consistent across the country. My sister was on her authorized weekend to be with her children, and suddenly 5 policemen raided her and seized her children based on a court order that was issued without warning or due process. She was not even given a reason for the first 2 years, and now, 4 years later, she has still not seen or heard from them. When she learned from academic and pediatric reports that they were missing almost half of school and ceased to grow even 1 inch in 4 years, which is extreme failure to thrive, she was rather barred from her constitutional right to seeing their records. In her case, she did not even report child abuse. The children simply kicked, screamed, and tried to commit suicide rather than go to their father, who almost killed each of them by head injury. Yet, he now has sole exclusive custody, and no prior adult who cared for them can have access to them. As shocking as this may sound, her case still counts among the milder ones I have seen. I do see some of the more severe ones, being a violence expert. But that is what had me delving into family court cases, and I can tell you it has not been easy to enter them, because the judges will usually wish to resort to their own experts, who usually don't go beyond a master's level training. And doctorate level experts used to be quite rare, are increasingly more distressingly part of it. Many loving parents are also professionally and financially ruined, charged exorbitant fees for evaluations, therapy, supervised visits, and child support, and then incarcerated when they cannot pay. If they try to fight back or to use the legal system as it is intended, they are retaliated against. Transferring custody allows the perpetrator to conceal his abuse, as well as to achieve the goal of tangential spouse abuse, which is abusing the children to torture the spouse. In my sister's case, she experienced 10 near-death episodes from stress and went from superior functioning as a former high-level government executive to requiring round-the-clock 24-hour care after an intensive care unit admission. I've seen courts and court appointees fish for pseudo-theories to try to justify these abrupt transfers, and this is where parental alienation and reunification come into play. Family courts have essentially produced opportunities for an entire industry of theories and methods unheard of outside of family court. Reunification camps can charge up to $40,000 for 5 days in a rundown motel. And I've personally seen a master's level so-called expert charge $500,000 for a report that was fraudulent, in my view, labeling the healthy, loving parent mentally ill after just 15 minutes of interview and then permanently removing the child on that basis. And again, these situations are not so rare. So when there is child abuse, the most critical mitigating factor is the loving, protective parent. But contact with that parent is often severed for many years, if not for the child's entire childhood. The oxymoronic reunification therapy, usually done with an actively abusive parent, is contraindicated in regular mental health practice. These family court confined practices maximize harm and not only embolden existing perpetrators, but generate new ones, since roughly 1/3 of victimized children move on to become victimizers themselves. These are the reasons why I have called family courts one of the deadliest places for women and children. Men can be victims of the system as well when mothers abuse. For this reason, I've come to call family courts an abuse industry. Almost 100,000 children per year are being gravely harmed, which brings in, for family courts, more revenue than all other courts combined. Countless loving mothers have died prematurely without prior health conditions or are beset with diseases unseen anywhere else in medicine. It is a serious public health problem that, unless immediately and profoundly reformed, will continue to cause great damage to our society and our collective future. I'm very grateful for your work. I appeal to every member of this august body to enact bold legislation that can help save the 100,000 children who are sent every year to fates worse than death, what psychologists call soul murder, not to mention the loving parents who are punished for the high crime of loving their children. You are pioneers in a critical movement, and your decisions will set the standard for the entire country to follow. And it certainly helps someone like myself, who trained to become a healer and has discovered a system that will counter any effort that we try. Thank you.
Thank you, Ms. Lee, for your testimony. Would you be able to leave us that testimony, that we could get that for the record? Would that?
Yes, if I could email it.
Absolutely. Yes, that would be wonderful. Thank you. I see we have some questions here, so we'll start with Representative Alfieri.
Thank you, Madam Chair. Dr. Lee, thank you for coming. I wanted to ask you about a couple of things I think perhaps I might have misheard. Did you say that 75% of males who contest custody abuse their children? Did I hear that right?
That is based on, yes, that is based on some, it actually isn't a scientific study, but it was based on a survey that was done by one of the activist organizations. Unfortunately, there isn't a great deal of scientifically rigorous study that is done on family courts because of the secrecy. Currently, there is a survey that is being done right now through Justice USA and myself that will attempt to bring more scientific rigor to these anecdotes.
And follow up?
Open that. Thank
yes,
you,
go right
Madam
ahead.
Chair. Dr. Lee, how big was that initial study?
Ms. Lee.
In terms of numbers, are we talking about 25 people or 25,000? I just find it hard to believe 75% of men abuse their children.
Oh, those are those who come to family court with contested custody, not men in general. Absolutely not. Family courts, I imagine the percentage is actually increasing because the word is getting around that one might even escape criminal prosecution if one entered family court. There's an interesting practice where if any other civil or criminal matter opens anywhere else, they're generally channeled back to family court because of the tradition of family courts being a place where things were adjudicated together.
And a second question?
Yes, go right
Madam
ahead.
Chair, thank you. You also mentioned diseases unseen anywhere else in medicine that women have. Could you elaborate on that a bit?
Ms. Lee?
Yes, women who simply drop dead in the courtroom, we normally don't see that without a pre-existing heart condition. Women die from suicide, from heart attacks, broken heart syndrome, cancers, soft tissue diseases in ways that truly we don't see anywhere else. Any place that comes close to it, I've also worked with law students who represented asylum seekers. I've seen it sometimes with political persecutees.
Thank you.
Okay. Representative Ehart?
Thank you, Madam Chair. And gosh, thanks, Dr. Lee. You said a lot, and I started to think I didn't know if we were going to have time to ask a few questions, and I'm sure I'm not even going to hit what I'd like to ask. So my first one isn't really a question. Did you listen to this morning's testimony? Were you here? Forgive me
Yes,
for not.
I
Okay,
have.
so knowing that, we heard testimony that, our police, and I'm not questioning our police, I'm just saying, that our police don't just go and get the kids. It sounds like yours just almost kidnap them, which is disconcerting.
When family court judges are involved, yes. They
Yes.
almost allow anything, whereas law enforcement cannot act independently if there is a family court judge involved. And so actually a lot of abuse cases that might have been intervened with are not because of the presence of a family court judge.
Representative Ehart?
So my first question then is, given the testimony that you have and where we are here in Idaho, is this something that you see in most states? I don't know your work sounds fairly extensive. Is this something that's kind of catching on and becoming more prevalent? Because that is disconcerting for sure. So that's my first question.
Dr. Lee?
Yes, it appears to be a practice that has been consolidating for the last 45 years or so. And states, even in the past 2 or 3 years, I would say, their practices have become much more uniform and much more severe. And it's been speculated that with the increased exposure, it was their defensiveness. In fact, each time there's a legislation that's passed, they have, as a rule, become more draconian and more...
The legislation has become more draconian?
No, the family court practices.
Courts, okay.
Yes.
Madam Chair, follow up.
Go ahead.
So you probably heard me say then, and I've said it many times, but in here that I personally feel like divorce court's big business. And I don't necessarily mean the court itself, but everyone is associated, with it, much like anything that government does. You require something in medicine, and boy, those prices just seem to swell. So you mentioned a few things on costs. I don't know that we've seen something cost $500,000, but one of my concerns is how costly some of the studies that various people have been, and we can see receipts, some of the studies that have been required, how costly that is, at least for Idahoans. So my question to you is much like the first. Are you seeing the trend increase not only in the costs, but one other quick example, we had a gal that I had spoken to, and she told me, and I hadn't heard of this yet, that she was forced to go get a study on how marketable she was for employment. So I guess I'm wondering, are we seeing across the board an increase, not just in costs, but in the required studies that those involved have to get?
Yes.
Dr. Lee?
That is one of the main means by which children are taken from healthy and loving parents by forcing them to go through a psychiatric evaluation, which is seldom done by a psychiatrist, usually done by an associate counselor, a mental health counselor. I've seen all kinds of labels that I had never encountered in my psychiatric career. And then after just a short interview, there's one psychologist, for example, if she's a clinical psychologist in Connecticut, who simply does if she's done 1,000 court evaluations, and that's her practice. I don't know what she could be an expert in if she doesn't do any practice outside of court, but her 120-page reports are all identical. Every one that I've seen. The names are changed and some dynamics might be adjusted, but the false diagnosis she comes up with, the 15-minute interviews and the 5 minutes with the children that she's seen, and the children are always uniformly transferred to their abusers.
Okay. And Madam Chair, last question, follow-up. So this one is harder to answer, but it's been at the heart of you kind of touched on it. You brought up all these problems, and they're pretty dramatic from your end, that you've shared. And my question would be, why would this be happening? Okay? And so the other question as to the why is, who, if any, who's benefiting from this?
I think you pinpointed the question. I've never seen a court where so much money is exchanged, even openly. Children spot suitcases of cash under the table, and judges are included. They're not, it doesn't always go through the circuitous route. Envelopes of cash that are given with discovery material to evaluators. And these things are reported to licensing boards, but the licensing boards will not investigate them as long as it's in family court.
All right. Dr. Lee, could you talk just a little bit, just briefly, on what kind of changes have you seen in your studying that you're doing across the states? What sort of changes are you seeing or what you recommend need to be made in some of these states and in fixing some of these issues that you see?
I think it's heavily related to the benefit that comes with doing this. When the child is given to the wrong parent, it of course sets in motion an entire course that a crisis would entail, that many more evaluations are needed, supervised visits are ordered, the case gets prolonged from what probably should have taken weeks or months to years, if not decades. And so I believe that there's too heavy an incentive to do the wrong thing. And also, to do the right thing, the cost can be great. Just as I described, family violence is quite prevalent. But society itself prefers to deny or diminish the importance of violence. And so when we think of family court, we think of two parents negotiating which weekends they will have the child, when in fact something much more serious happens within them. And the judges themselves could be in danger. So if you had the choice between possibly being murdered by the unhappy party or gaining lots of benefit, even millions of dollars that the perpetrator would be willing to pay for your covering for their crimes, then which would you choose? So there's just too much incentive. In my view, once there is a question of family violence, I think it should go straight to criminal court. There are too many personality features of perpetrators, their skillfulness in presentation, their beguiling of evaluators, and their framing of victims that criminal courts are much better equipped to deal with. It makes no sense that family courts should be the place where the most violent perpetrators of society congregate and find benefit.
Okay, thank you. Any other questions? I'm not seeing any. Thank you so much for being here. We really appreciate it. And yes, if you would email your testimony, that would be great. We'd appreciate that.
Thank you once again.
Thank you. Okay, we want to thank everyone for their time again and appreciate it. We are going to now move over to public testimony, and my co-chair, Representative Scott, is going to follow that through for today. So I'm going to turn the gavel over to her, and we will proceed with the public testimony.
Thank you. Sorry for that short lunch. I did want to just make a quick shout out to the staff that has showed up today to help us, because we're not always in session, as you know. So Elizabeth Bowen, Jennifer Keish, Lace Sylvie, Linda Jensen, and Soren Jacobson, we appreciate you all being here. And if there's anyone else I missed, we appreciate your time in Idaho State Police. So we're going to start public testimony, and I'm just going to reiterate what we read this morning real quick. It just says that we, the legislature, we write the law, we make the law, but the courts decide the cases, and we are not here to second-guess decisions of individual judges or to undermine the integrity of the courts. Now, what we want to make sure we understand is places where we can find policy changes and legislative changes within the law. That's what's in our purview. We can't reverse a court order or do anything like that. And I know a lot of this will probably be emotional for some, and we're just going to try to get through everybody. So we're going to set it at 3 minutes, but if you need to go over, we'll be pretty lenient, and there'll be questions. So I would, if you can try to just get to the facts and talk about the problems that you had within the system itself, and what that looked like, what the problems were that we may be able to address in policy. So I'm going to go right to a list. I have several different lists up here floating around, so I'm just going to pull a name. Kimberly Gannier. Is Kimberly here? Go ahead and state your name and where you're from, and we can go from there.
Okay. All right. My name is Kimberly Jenner. I'm a mother, a nurse, and a citizen of the state. My family court case was heard in Ada County. The system is extremely broken. It protects itself and exploits children and families in its wake. My ex was able to weaponize the family court system against me and filed for full custody in May of 2021. There are no limits of how often and how much you can file against a person, and the extreme financial burden of paying for legal representation against frivolous filings is something that hardworking middle-class people can't even afford. But if I didn't put in a fight, I would have lost my children. So I've taken on multiple jobs. In 2022, a psychologist was appointed by the court to do a parenting time evaluation because my ex had claimed I had mental illness and was parental alienating my children. The psychologist appointed by the court demands a $12,000 retainer for an evaluation, and that report is not released until he's paid in full. Overall, his report on my family contained baseless theories, twisted narratives, but he concluded that shared legal and 50-50 custody was in the best interest of my children. He also warned that taking the children from their mother would be traumatizing to them, could increase suicidal ideation, and require inpatient psychiatric treatment. Judge Walker ignored this report and stripped me of all of my legal and physical custody of my children, labeling me as an alienator and stating that I was possibly mentally ill. I was stripped of all of my rights and ordered into supervised visitation for 2 hours once a week with absolutely no contact with my children outside of that. I was ordered to pay $100 each visit, child support, and the full cost of medical insurance, even though I was not given the right to make medical decisions for my children. What the psychologist predicted came true. My daughter was admitted to an inpatient psychiatric facility in Bellevue, Washington, where she spent 6 weeks being treated because her physical and mental health deteriorated rapidly under this court order. After 2 years following this order, I filed in 2024 to return normalcy for my children, but was met with immediate prejudice from Judge Walker. Judge Walker went out of her way to coach the opposing party on what they could do to get this case dismissed. She even sent my attorney and me out of the courtroom when we refused to be silenced on my children's disclosures of abuse. My case was then sealed. My attorney withdrew from the case because she could not help me through the frivolous filings and the vendetta this judge had. She encouraged me to drop out as well and wait to see if I could get another judge on my case. This is when I knew I had no other options left. I dared to speak the truth publicly in a campaign to vote no on Judge Walker. Immediately, that very judge hauled me into the courtroom and interrogated me on my advocacy. She even pulled my teenage daughter into chambers alone without legal counsel and grilled her as well. That's not just judicial overreach. It's election interference, it's intimidation, and it's a grotesque abuse of power.
You're at the 3, so
Okay.
kind of maybe.
This same judge took sealed documents from my case and shared them across other cases, contaminating those procedures that had nothing to do with mine. I, to this day, am still unable to get documents for my case, and I have an open case. But this isn't just about Judge Walker, it's about the system that enables her. My daughters found naked photos of herself and her sister on their father's iPad. He had been recording them in his apartment bathroom without their consent. This was reported to CPS, Meridian PD, and even the FBI got involved, but nothing happened. They dismissed this matter. My children were silenced. Judge Walker said she would even throw my daughter into juvenile detention if she didn't follow the court order and go home with her dad, even after he had asked to look at her vagina.
Okay, we probably should kind of wind it up here.
Okay. In every other position of power, with anyone who holds a licensure, you can hold them accountable for negligence and malpractice, but not in family court. I'm now on my 3rd judge, my 3rd attorney, and I've spent over $200,000 fighting this battle. I'm not here asking for pity. I'm demanding accountability. I urge you to shine a light on these hidden courtrooms. Thank you.
Does the committee have any questions?
Thank you, Madam Chair. Kimberly, I am so sorry I did not get your last name.
Jenner.
Jenner. So, Ms. Jenner, you just stated that you spent over $200,000 in what's the time frame?
From 2021 till today.
So $200,000 in 4 years. Madam Chair, follow up?
Go ahead.
Then, Ms. Jenner, my other question is this. In any of this process, did you find any help from anyone, and I'm not talking your attorney, did you and your attorney find any help from anyone, anywhere, or any recourse during your proceedings?
Ms. Jennings?
No, like I said, I'm on my 3rd attorney and nobody knows how to get me out of this.
I have a quick question. So the sexual stuff going on, has that been reported to CPS?
Yes.
Go ahead.
All right. Thank you, Madam Chair. So my question is, on that note, when it was reported, what happened after that? Was there any police report taken? Was there any information that was given? And then what transpired that no action was taken, or what were you told?
Ms. Jenner?
So CPS referred it to Meridian Police Department. They showed up to our supervised facility, looked at the photos, and immediately turned it over to the FBI, because now we've got physical evidence. The FBI came in and questioned us for a couple hours, separated me from my children, questioned us, and then released the kids back to their dad, basically dismissing it, saying I could ask for the report. It took me about 5 months. The report was completely redacted, and I was told I'd have to get an attorney to file and see if they would unredact some of the report for us.
Representative Erickson.
Thank you, Madam Chair. My question is specific to back to your mental health concerns when you initially went to court. If you don't mind, I mean, I don't want to pry on your mental health diagnosis, but if the psychologist is writing a $12,000 report and they're putting in some kind of, what kind of diagnosis are they putting that caused the judge to make that determination on your behalf with your children?
Ms. Jenner?
I was not given any mental health diagnoses. I was labeled as a parental alienator.
Follow up with that. Who labeled you that?
Judge Walker.
Okay, the judge. Okay. All right. Any last questions? Okay, we are going to move right along.
Thank you.
Thank you for your time today. Next up, I have Nikki Adams. Is there Nikki here? Just introduce yourself and where you're from. Start when you're ready.
My legal name is Andrea Adams. I go by Nikki. I'm from Boise, lived in Idaho my whole life. Can I continue? And on this USB, I have internal emails between prosecutors, police, state-ran counseling to conceal and hide evidence. I have a prosecutor emailing an officer if my daughters have ever reported abuse. That officer said no. 4 weeks prior to that email, my daughters had told me that the abuse is increasing. I have emails, internal emails of all these people that went in front of Wiley Denner out of Bonneville. He laughed. I've been told by the police they're not going to investigate the corruption and concealing this evidence. Why? Somebody asked earlier who benefits from this. There's jobs created. Idaho is taking part in a Kid for Cash scheme to create jobs, to harm children, put them in counseling, state-ran counseling, and send them home to an abuser. The professional earlier, that is the worst thing you can do. You are telling these children, no matter who you talk to, no matter what happens to you, we do not care. So when I leave and I'm done with this testimony and I walk out of this door, none of these policemen are going to say, give us the name of the police that you have on that email. There is zero accountability. I am no longer interested in this abuser. I want to know why these police officers are allowed to conceal this kind of evidence in the state of Idaho. I have now been diagnosed with MS. My eldest daughter now has epilepsy and has seizures. If these children do survive this, what's their life like? Don't ask me about the money that I've spent. Don't ask me about my time, and don't ask me about what's taken away from me. I want answers. Why aren't people being accounted for? And when I write into judicial committees, the state bar, and anybody else, why aren't these lawyers that I have on internal emails coming into courtrooms and lying? They're taking money from abusers. This is so far from what do we do in the family court? What do we do in our police stations? What are we doing in these juvenile centers? What are we doing in the state of Idaho? That's all I have. Does somebody want this evidence?
It would be great if you could give it to the secretary, and we will get this evidence to the committee members so that we can have it on the record.
There's a lot more internal emails than what I could get on there, but.
Okay, you know. we do have a question. Representative Ehart.
Thank you. And Ms. Adams, we're doing this because of concerns. We're doing what we can as a part-time legislature who cares. My question to you, even though you didn't want to say, don't ask me about it, I think that it also helps, though, our statistics. Can you give me an estimated amount of how much money you've spent and the amount of time, please, that this has been going on?
Ms. Adams?
It's close to 200,000. This has been going on since 2015.
Okay.
which if the police would have done their jobs in 2015, this would have ended in 2015. I was choked, passed out, my head went through a wall and had a serious concussion. The only witnesses were the children. He was never prosecuted. I do not know why. Who told them that I didn't want prosecution? What is going on? So yes, the time I started representing myself, because I could see that no matter what I did, how much I paid, I am getting forensic reports back, one from Tom Bennett that said, this is merely end of relationship violence. Really? Because I was always told growing up, violence, that's in black and white. You end a relationship when there's violence. What are we minimizing this to? And why? This is to mess people's lives up, create jobs, and make money off the blood and tears of children.
Okay, I think we have another question. Representative Alfieri.
Thank you, Madam Chair. Nikki, if I may call you that, I almost don't want to dig into this, but I think it's important that we hear this. Are you telling us that you went to police officers with evidence of violence and they ignored you?
Yes, I am told by the Idaho State Police Detective Wall. I called in and I said, I have obtained evidence that the police covered up sexual abuse of my children. I want them investigated. He started. I was then contacted by his superior out of Bonneville. I can't remember the guy's name.
I'm going to interrupt for 1 minute. We have got to be, we're not.
Yeah, I was asked a question.
We want to try to not bring up names.
I don't want to go to
and
names,
direct things. We want to talk about the process and the system. And so by calling out names, then it's,
yeah, we don't want
it
to
could
make
be
accusations.
accurate.
Nobody said otherwise, so I didn't
So, and
know.
I guess maybe I didn't make that clear. So we want to make sure that we don't mention names. We could just say the co-parent or the judge or the cop. Try to be more general, but if you want to give, evidence to the committee of more details, then we could take that in. But let's just not.
To answer
And I
your-
apologize if I misled you in that direction.
Same. So yes, I contacted the Idaho State Police. One started the investigation. I was contacted by his superior that they will not be looking into the matter. I have contacted Idaho Legal Aid that is supposed to help with cases. They said, we can't help with this. This is criminal. The police tell me that they can't help with this. This is civil. This is full-on criminal to have people withholding this kind of evidence.
Okay, if I may follow up.
Okay, go ahead and follow up.
So when they said they would not pursue it, was there a reason given that they would not pursue it?
Ms. Adams?
It's civil.
It was a civil action is what their answer was, not a criminal action.
That's
Is that
what
right?
they're saying. But but that is criminal. That is against Idaho law to conceal evidence. An officer go into a trial, custody trial or not, that is a trial. Swear in as an officer. And when asked if the child ever reported sexual abuse, and she says no, and when she is asked, is there police body cam with the other parents saying that they do allow drugs, they do give them drugs, and they think she was raped but didn't take her in for a rape kit, and nobody has investigated anything. And when that officer says no, that's a crime.
Okay. Is that all? Thank you for your testimony today, Ms. Adams. We're going to try some remote testimony. Is Joseph Erickson there from Boise?
Okay, I'm here.
Okay, go ahead and introduce yourself, and then you can just start with your testimony. You have 3 minutes, and not sure if you heard, but we're going to just mention generalities. We're looking at ways we can improve policy and law, so we don't want to, be coming after judges or cops or something. You just want to be very general and try not to mention names. Okay, thanks.
I understand. My name is Joseph Erickson. I'm a resident of Boise. I have a few items that are they're less concerning regarding the individual circumstances and a little bit more relating to the statutes. And so the first one that I wanted to kind of bring up is that is in domestic relation law and basically in the Idaho rules for family law practice, Rule 126 specifically. In subsection B, it talks in regards to that legal responsibility should be divided in proportion to the guidelines of incomes. And so reading further into that, I do believe that the concern is in pro rata apportionments. And I know that that was discussed previously, but pro rata apportionments do serve parents, both parents, as sort of a punishment, in my opinion. So it's a very complicated process, the complicated process in determining child support. And so it relates to overnights, it relates to the ratios, it relates to income. And I think that we could probably review some of those statutes and determine whether or not within those policies, whether or not it's necessary to make that such a simple process in regards to, or we couldn't make it a simple process in regards to using overnights as the sort of narrative behind how that's apportioned. I do believe that pro rata apportionments personally have affected my family, where my current situation, I have a 91% assessment. So regardless of any court services, whether that's a parenting coordinator or whether that's medical assessments or any type of fees or any type of expenses whatsoever, that position that puts me at 91% responsible. So I'll move on with the next one. I do believe that the parental alienation needs to be defined within Idaho code. However that needs to happen. We need to have a definition of that, whether it exists within the state statute or if it's to be gotten rid of and not accepted within the magistrates and within the family courts. There definitely needs to be some way for us to look into whether or not we can provide precedent from another state to allow for parental alienation to be defined within the Idaho statutes. One example is that co-parenting can be nullified when one party is able to speak poorly about another parent in front of a minor child. The child is adversely affected and it causes a high conflict, potentially cause high conflict visits with the other parent. Idaho does provide for a supplemental form attached to a divorce decree prohibiting these behaviors, but it really provides no provision for enforcement without filing a contempt charge for civil sanctions at the expense of one of the parties.
You're at 3 minutes. So you're at 3 minutes, so just try to wrap it up and make sure you get all your points out.
And then the last thing I have too is that I think it is concerning that the language regarding civil statutes, not just in family courts and not just relating to these things, but statutory language regarding in communications, harassment, defamation, slander, stalking. The language is outdated in regards to the form of communication that can be used. So I think that the latest adjustment was made to include facsimiles, which is obviously outdated. I think that there needs to be some sort of update to the language to include cell phones, social media platforms, things like Facebook, Snapchat, Twitter, some of those things that are out there that would allow for third-party incitement, potential harassment, things like that. So law enforcement is extremely hindered in protecting individuals against behaviors such as stalking because the current bill doesn't address all the potential communication forms. Thank you.
Thank you for your testimony. We might have questions. Any questions for Joseph? No questions, and we see you emailed us your testimony, so thank you for that. Next up, is there Aubrey Shawn here?
Good morning. Thank you for allowing me to speak. I'm a mother of 8 children. In 2015, I was living in Middleton, Idaho, and my husband at the time was arrested for domestic violence. And the day after I gave birth to my 8th baby, I went to the courthouse for his follow-up hearing. And I, since then, have been fighting for my children in family court. I immediately filed divorce after that, and he retaliated by taking me back and doing everything everybody's explained here, especially the doctor that spoke explained my situation almost perfectly. So my psychologist, I most recently was ordered psych evals after 10 years. My ex-husband was not, but my psychologist wrote in a statement that he wanted me to read. He has absolved me of any mental disorders, even though the court removed all 8 of my children, and I haven't seen some of them in 10 years. I had just got back a few of them this year or last year, and my former husband has me on 2 criminal charges now because they were about to restore my overnights, and he didn't want that to happen. So he alleged 2 false criminal charges against me. My psychologist said the facts in Ms. Erickson's case are not abstract. They are recorded, measurable, and validated. The courts have ignored licensed, unbiased, scientifically supported findings. Taxpayer-funded agencies have failed to act on actionable clinical recommendations. The impact of unchecked manipulation on these children will be long-lasting until accountability, neutrality, and evidence-based practices are reinstated. This is not just about one case. This is a systematic failure, and it must be changed. And I will say all the parenting coordinators, evaluators, and those people have kept me and charged me thousands of dollars and refused to allow my children a relationship with me. So that's all. Thank you very much.
Thank you. Is it Ms.
Erickson?
Erickson, sorry about that.
Oh, you're
Okay. Question from Representative Ehart.
And Madam Chair, before my question, I am so sorry. I thought it was Aubrey Shaw.
It's Erickson, sorry.
It's Erickson. Sorry, I'm a note taker. I'm just
You're
going to
fine.
change
Shan is my middle legal name.
Okay. So, Madam Chair, Ms. Erickson, I don't know if you were sitting in here this morning.
Yes, I was.
Okay, so it's very interesting that the thing that I brought up a couple of different times, which was my frustration that it seems like just about the time a court appointment will come up where there's going to be a change in the direction of the kids or that request, that boom, the opposite parent seems to come up with a claim such as in yours, but we are told it didn't happen much.
No, it happens very frequently from everyone I know that has had their children removed by these judges. My son had just been molested in 2019. He was 4 years old. I rushed him to the emergency room. He was bleeding, and the detective at the time told me, "You just have battered women syndrome," and immediately my ex-husband filed an emergency motion and took full custody. He was strapped in his car seat and mutilated genitally. They ignored all the forensic pictures, and even the evaluators it was reported to the parenting evaluator, April, I'm sorry, no names, and she ignored it and instead recommended father have more custody than me. It's been traumatic for my kids. My oldest daughter reported sexual abuse and said, "Mom, the police don't believe us. They won't believe us." And the police officer at the time when I reported on her said, "What do you think? I just carry a rape kit in the back of my police car?" They've just been horrible to me, to my children. And I have friends that are police officers, and I really respect our law enforcement officers, but when it comes to one parent biasing their opinion against another parent, it takes on a totally different feel.
Madam Chair,
Go ahead,
follow up.
Go ahead.
With some of the things mentioned, one of the things that's frustrating about a lot of our proceedings, not just here, it could be in the courts, when it gets to a he said, she said, or anyone said, it's evidence. I'm assuming that you probably, like others, have tracked that which has occurred and that you have a history, a trail, you have evidence, and you have, and is that something that can be submitted?
Yes, it is.
Okay, all right.
Senator Nichols.
Thank you, Madam Chair. My question for you, Aubrey, is looking back into your situation, because this is over a decade long, it sounds like, where can you pinpoint where you were put into a position where things could have been done so much differently, but where was the ball dropped initially with your situation? What would you say?
Go ahead, Aubrey.
I would say, thank you, I would say that it was kind of from the onset, because he was able to change the narrative to make me look like the abuser with no evidence. So there was just never any evidence of any neglect or abuse on my part, but they were still able to make rulings to take away all my contact with my children. So there needs to be evidence to show that there is a reason to take away the contact from one parent and give it to another. Even the court coordinators never had any proof or any evidence, or the court evaluators, but yet they still kept getting retainers from me and kept charging me money, but not allowing me my supervised visits or anything like that. And then when you have a doctor of psychology who's worked for the military and done background checks for like different presidents and stuff, and he's saying these things and they're ignoring him, they're ignoring the professionals that are inside the court system or working with them. My children were with my social worker back there, and she reported to the court, she reported to the coordinators, and they ignored her and misquoted her and left out her statements. So I think that's where the problem breakdown is when they won't listen to any professionals except those inside their system that are appointed by them, by the judges, not by me, not by the other parent, but by the judges appointing these professionals who don't even have licensing. Like, they could just be anyone.
Representative Erickson.
Thank you, Madam Chair. The question is specific to what you spoke of a little earlier related to the genital mutilation and those kind of things. I was a little confused. Was the perpetrator their father or some other gentleman? Okay, because I was concerned that maybe they were putting forward a refuse to protect on your end. So you're saying that the perpetrator was
Correct.
Their father, and then okay, thank you.
So I have two quick questions. Before you had your children taken away, did you have any criminal record, or was
Nope, he had been to jail for domestic violence, but I had no criminal record at all. This year is the first time he's alleged criminal charges against me, and that's because my psychologist met with the parenting coordinator after 5 years of me not having my children, and they were getting ready to restore overnights, and so he immediately filed on, I was getting the kids for 8 hours, and he immediately filed or called the police and reported that I had abused my daughter. The police responded, CPS and the police dropped all of their investigation, told me to go pick up the child, and he got a false protection order. Then he fabricated a screenshot saying that I violated the protection order, which is false. But they want me to plead guilty to that because otherwise my daughter has to testify in court.
Okay.
Can I just follow on that real quickly?
Okay.
Sorry,
Representative Ehart.
Chairman, just given what you just asked, so they wouldn't respond to your complaints, wouldn't pick it up.
No, I was a
but they
battered
immediately
woman.
responded to his.
Correct. And this has happened over and over the past 10 years, probably about every year. There's a major incident like this, and about every 3 months CPS, I have over 200 CPS reports that are all unfounded, filed against me, which means my children have been through 200 interviews by CPS at least.
Okay, we have two more questions that I'm aware of. So Mike, I have one more question. You mentioned that that these places that you're supposed to go get classes or whatever, that the judge is appointing that, but they're not certified. Do they have licensing, or do they not have licensing? Is it just can you explain that?
Sometimes they don't have any licensing. I think the one that my children are seeing right now, I could say her name, but she's a counselor appointed by the court. I'm supposed to pay for her for the last 5 years. I haven't been able to have any contact. She refused to take their last counselor that they were in counseling with when I was still seeing them, refused to take all of her notes, and has been billing me exorbitant amounts of money to bias my children against me and tell them that I'm the abusive and bad parent.
Okay. We have Senator Carlson from Zoomland.
Thank you, Chairwoman. And Aubrey, I just have a quick question for you. Was it mandated that you have a parenting time evaluator? And if so, was that mandated by the judge, or how did that come to be, and did you have a choice on who to pick?
Yes, after after their father did that to my son and he retaliated by filing an emergency motion, they did require a parenting evaluation on both parents. The evaluation came out biased towards him, And yes, it was mandated by the judge.
Did you have a follow-up,
So,
Senator?
yeah, sorry.
No, go ahead.
Yeah, to clarify, the judge gave you one name or gave you a list of names?
I only ever heard that from my attorney that we were being ordered to a parenting evaluation by this person, and that was it. There was no choice.
Okay, thank you.
Thank you for this testimony today. Oh, wait. Two more questions. Representative Gannon.
Thank you, Madam Chair, and thank you for being here today. But for me to understand better what's happening in your situation, can you give me your case numbers so
Yes.
I can look them up on iCourts and see what's...
Yes, I can give you all of them. So my family court case is in Canyon County. It's CV.
Maybe we should do this after.
Okay.
Yeah, it's all public
Yeah, we
record,
want to,
but-
okay, I know it is all public record, but we should probably, remember, we are only looking at policy. So we're trying to understand, like, what bills can we pass that would help solve these problems that people are dealing with? We've all had many calls, and we're trying to understand the system better.
Yeah.
We're not in that judicial world, and so we're just collecting information. So we'll leave it at that. And you can always call legislators not in this committee, share your concerns. I think we're going to move on.
Thank you.
Madam
If I
Chairman?
could just leave you with that, I really believe that dissolving the court professionals and removing them and allowing parents fair access to Medicaid covered or private insurance covered professionals who would work with both parents would be a huge thing.
Okay, Representative Gannon?
Yeah, Madam Chairman, I just did want to say that maybe if I can get the case numbers afterwards, but there are a lot of charges being made against our police officers and police in general, and I think it is important to look at it in that frame, to look at both sides and make sure that we're coming to the right decisions in these cases.
And I will reiterate.
And our judges, too.
Yeah, that is the complexity of what we're dealing with family court. And what we realized is family court, health and welfare, police, judges, prosecutors, it goes through many jurisdictions. So we're just trying to understand the process and the problems. So
When criminal court judges divert things back to family court judges when really it's a criminal problem, it becomes escalated because then you're putting children at risk, at high risk for being abused.
and that's probably something we will dig deeper into. Okay, one last question from Representative Ehart.
Thanks, Madam Chairman. I just wanted to ask the same thing, and if everybody just wants to mention it, it'll be helpful. From the best guess, how much money have you spent over how much of a time period?
I'd say 200,000. And I'm just a massage therapist and substitute teacher.
Over how long?
That was from 2015 to current.
Okay, thank you.
Thank you for your
Thank you.
testimony today. Okay, is there an Andrew Patchett here? Please let us know your name and where you're from, and start when you're ready. Thank you.
My name is Andrew Patchett. I'm from Emmett, Idaho.
Go ahead.
All right. In 2022, I was had a move-out order and restraining order put on me because I had found things that my ex was doing that she shouldn't have been doing. During that move-out order, restraining order, I have 8 kids, and there was 4 of them above the age of 10, and they were standing on my porch telling the officer that he was removing the wrong person, and that their mother had lied to him. And the officer told my kids to get back in the house, and they were not of age to speak in their own behalf. And so I was removed from this house, and my ex was sitting down the road, about a mile down the road. I lived at, quite a ways out in the country. She came home and told my kids that, all these horrible things, that I had raped her for them to be conceived, all this crazy stuff. So going fast forward, we start going through divorce, and just constantly, because these allegations were made and there was criminal charges with those, I was prevented like the speedy trial. And so the judge wouldn't allow certain things to come up through our divorce court, because he didn't want to like basically make myself look like I was guilty of something, guilty. Through all this, constant allegations were made, false allegations, it came out, and I had it ended up having to get a criminal attorney through these. And so through the criminal stuff, I found out later that my ex was having lunch with the prosecuting attorney. And this cost me, a great amount. But the biggest problem I had was, so this restraining order was for 90 days. And so I wasn't able to be around my kids for 90 days. And my oldest son, who stood up against his mother, she kicked him out of the house. And so he went to go live with his sister, or with my sister, sorry. And it completely messed him up. Like, he still has problems today. And so he couldn't be with me, and he wasn't going to go back to his mom, and because the restraining order was in place, he couldn't come live with me. So it completely destroyed this kid. Moving fast forward, I ended up getting divorced. The judge, signed a divorce decree, and then I got remarried, and then my ex went before the court and talked to the prosecuting attorney, and they filed bigamy charges against me. So in Jim County, they filed felony bigamy charges against me and arrested me. The same judge that filed the divorce decree signed the arrest warrant for $5,000. So again, had to go through all that. Those charges were eventually dropped with the attorney I had. Finally, the prosecuting attorney got tired of, I think he found out that she was lying to him. And so the prosecuting attorney, wanted me to pay the court costs, and that was it, and leave. I went before the judge. It was the first time in that year that I was able to speak for myself because of the allegations against me. And I spoke about how I felt that the court did their misconduct in my case. I didn't name names, nothing like that. It angered the judge. He fined me $1,000, a year probation, bench probation, if I messed up in that time, that he would I'd get 3 months in jail. And so totally different than what the prosecutor was wanting. It was even way more. Sorry.
We're at 3 minutes, so I know it goes quick.
All right,
so just try to, we're
all right, so
following.
In November, there was false charges against me and my kids for sexual abuse. CPS was involved. Those allegations were completely dropped. The CPS wanted a psych eval for my ex, and because they were worried about her mental state. Because CPS didn't have any, backbone to make her go through this, she didn't do anything. Didn't listen to anything the CPS had to say. There was no consequences. I also had a parenting coordinator who was working with us, and because the parenting coordinator didn't have any backbone or they had no consequences. So my ex had no consequences, and so the parenting coordinator dropped us also. And whenever I asked, just one more thing I wanted to add. So whenever I asked the CPS agents why they weren't prosecuting her, they said, we can't because we don't have any foundings. Like we don't have any way of doing that. Whenever I spoke to the Sheriff's deputy that was over the case asked him like why she isn't being prosecuted. He's like, well, there has to be a victim and you'd have to file a report. So I filed a report and they still didn't do anything.
Thank you, Andrew, for your testimony. Do we have any questions for Andrew? Go ahead.
Oh, unless Representative Ehart wants to ask her question. Okay.
Okay.
Yeah.
Senator Nichols.
So thank you, Andrew, for being here. I'm just making sure that we're getting this on the record too, but how much money have you spent on this and how much amount of time has been involved?
Over $150,000. And because of false allegations and slander on Facebook, I used to be a mechanic and I've lost, tons of money through that. And then because of housing situations and stuff like that and not being able to have my own business because it was taken away from me, I've ended up basically couch surfing, trying to find somewhere to live because of the cost of living so high.
Madam Chair, just to
ahead.
follow up, and when did your process start? How long ago did this start?
2022.
2022, okay, thank you.
Yeah.
What county were you from?
Jim County.
Jim County, thank you. Okay, I think that's all our questions. Thank you for your time today. We do really appreciate it. Next up, we have Veronica Bays. State your name and where you're from and share.
Thank you. Good afternoon. My name is Veronica Baez. I'm a mother, a Christian, and a Latina. I've lived in Idaho for over 33 years. I served as a soldier in the Idaho National Guard for close to a decade, a doctoral candidate, and I'm a COO. I have no criminality, I don't smoke, I don't drink, and I've been celibate for over 2 years. None of that mattered when I walked into family court. Earlier this year, I sat in this very Capitol and heard Madame Rubel say she would choose a firing squad over losing her parental rights. Unbeknownst to her, parents in Idaho court never even get the courtesy of a firing squad. They take your children without evidence, without cause, and without an actual termination. It is the family court's silent execution. When my case began, I was a local hospital executive. I wore this exact suit on a hearing day. My attorney pulled me aside after and said, "This judge hates you. Maybe she just hates other women. I'm not sure, but you're dressing too professionally." The judge, Diane Walker, issued a temporary order that became permanent. Diane Walker didn't disclose until later that she had a close personal relationship.
Ma'am, we're going to try to not name specifics if we can.
Sure.
Okay, perfect.
She had a close personal relationship with my co-parents' co-workers. He is an attorney. By the time she said, "I play tennis with one and go to lunch with the other," custody had already shifted. The damage was done. My boys were just 3 and 5. Today they are 6 and 8. They have been hospitalized for dehydration. They've battled staph infections, physical and mental abuse, left with untreated conditions categorized as skin infections or STI. One of them disclosed sexual abuse. A physician documented wounds, abrasions, and lacerations to the buttocks and immediately contacted police and CPS. That should have sounded alarms, but instead of protecting them, the court silenced me. The female judge reframed the disclosure. She sealed the records. She banned me from contacting CPS. She discredited law enforcement. She acted not as a neutral arbitrator, but as an agent of suppression. During the same period, we had a court-ordered parenting time evaluation conducted by Dr. Todd Bennett. Under the Idaho Code of Judicial Conduct, Rule 2.9a, a judge is prohibited from initiating or engaging in ex parte communications concerning a pending or impending matter. Despite this, the female judge communicated privately with Dr. Bennett during his evaluation process, a serious ethical violation that she boasted in the courtroom that she could do, and it showed. The evaluation was biased, selective, and failed to incorporate key medical records and factual history. In his report, now sealed from the public, Dr. Bennett discounted verified abuse disclosures and medical records and minimized the ER documented sexual trauma that prompted law enforcement and CPS involvement. And when I spoke out publicly, when I launched a Vote No campaign, she retaliated against me by filing a Sunshine Law complaint against me. It was unfounded and dismissed, but her message was clear: stay silent or be punished. Even now, almost daily, court staff watch me and online stalk me. After all that, Judge Kyle Scow, the male judge, took over. And instead of correcting the harm, he praised Diane. the female judge, his mentor. After a trip out of town with her for an event, he sealed my case entirely, repeated her conclusions, denied my witnesses, 52 of them, because the list was filed 1 day late by my attorney, whether by design or incompetence, I may never know. Then he ruled my testimony was objectively and verifiably false, even though he didn't hear it himself. Even the female judge admitted she could not, for the preponderance of the evidence, find that I had falsified any claims. The male judge then denies me all access to my records, so I cannot file complaints. Still, it has been over a year since my babies were home. I was forced into supervised visits, $100 each, and I have done around 20 or so of them. I have spent over $200,000 in fees. I sold my home to keep seeing my sons and gave my co-parent literal cash for kids. If I were dangerous, why could I buy time with my children? Fast forward to now, 1 minute. Fast forward to now, my co-parent is withholding them completely. I've gone to the police 5 times or more for custodial interference. No help, no answers, just one agency punting to the next. No justice. The option I am given is to go beg my abusers. The opposing attorney, Sam Dotterskatz, who hides the abuse of my children in the robes of the female judge and the male judge, for my God-given and constitutional right to my children to be returned, and most likely spend another $100,000 or more doing it. After sitting with hundreds of victims during my campaign, I finally realized that it isn't about gender. The female judge doesn't hate women. It's about power. It's about the weaponization of the bench. In Idaho's family courts, the more egregious party gets the kids because the protective parent fights. And in fighting, we feed the system. You won't abandon your child. You'll mortgage your home, you'll work 3 jobs, and you'll lose your children anyway. But you'll keep fighting because that's what a protective parent does. Eventually, you'll get your children back and spend years healing the unnecessary trauma inflicted by the weaponization of the bench, the abusers it empowers, and the judicial activists who sit upon it. Thank you.
Thank you for your testimony today, Veronica. So the quick question is, when you mentioned the amount that you put in, to what, 200,000, between what period of time?
It's been over the course of 3 years, but 2 years were of litigation, so 200,000 in 2 years.
And do you currently get to see your children or not?
I do not. They're being withheld.
Do you have any criminal background or no? So they you just don't get any custody. Did you get any visitation or
the court order last? We sold the home and then I paid an exuberant amount to essentially buy custody back. And in the court order, a reunification therapist was assigned. So once I underwent supervised visits, I was to then go into the next step plan, which she would sign off on. She recused herself because that's not within her scope of practice. And during the Vote No campaign, people within her department or within her office were very vocal about their support of the judge. And so she recused herself from the case. And so there's no one to sign off on that. My only option is to go back to court, is what I'm told.
Senator Nichols.
Thank you, Madam Chair. Veronica, my question is this. So looking back on your situation with the things that you've been dealing with over the last few years, where do you think the system has failed you?
Veronica?
I will say that the system itself, you know, I know there's a lot here and everybody has different relationship with the police officers. I had a police officer from the Meridian Police Department who championed for my children, even argued against the judge in court. So I will say that no matter what you do, it goes to the judge. The judge's discretion is where it has failed. We're not allowed to go to CPS. You have to return it to the judge. If you do get in front of CPS, that CPS worker is sometimes someone who holds an associate degree, and not taking that away from them. They just may have less experience and they're not going to champion someone in power. And so again, that report gets given to the judge. So I think that while many things may not work as intended or as they should, ultimately it's the judges that failed.
Just to follow up.
Go ahead.
Thank you. And on that, so it sounds like there's definitely some sort of situation with a few of the judges that you've experienced.
Yes.
are you allowed to be able to get your case moved to a different judge or to something else where there's maybe not like a bias or something else that's going on? Is that possible to do?
I don't know all of the options. Again, I'm not an attorney, but I know that one that was presented was when there was an attempt to seal the records and there was a clear bias from the judge, was an interlocutory appeal. Filed an interlocutory appeal with my attorney at the time, and the problem is that it goes to the judge who is abusing you. And so you hand this document to her and you say, hey, please let me go to the next court or to another court to be heard. And then she says no, which she did. The other one is a change in venue, but I've asked that and request that from attorneys, and they say, well, you both live in this county, so where would you go? So we would have to either, I don't know. I do know that the advice I keep getting is, oh, you could just leave the state. And I don't want to. I'm an Idahoan. I shouldn't have to. In fact, they should be embarrassed to walk out in public. We shouldn't as parents.
Representative Ehart.
Thank you, Madam Chairman, and thank you, Veronica. So with the very question that Senator Nichols just asked, just clarifying that the judge under whom or who presided over this was a magistrate judge.
They both are.
And along those same lines then, with some of the testimony heard earlier from our commissioner, albeit short, I'm guessing you would, if there was a magistrate commission that was in place, you'd at least have had a place like that to go to if it wasn't just a 18-month commission. If this was a long-standing commission, it's at least a place that you'd be able to appeal, and I'm guessing you'd be in favor of something like that.
Veronica?
Thank you. Madam Ehart, I think that any avenue would be amazing to have. I think that there's not a lot of options. And I apologize, I lost my train there, but having a magistrate commission and someone that could take it up would definitely be, something that would be good. I think right now, our state, from my last, just researching myself, is one of, I believe, 6 states that actually has like a report card for the judges. But again, it's all private, so you can't see what is being done behind. And I think that's the biggest thing, is there's no avenue to go to besides just feeding the system. Yeah.
Thank you for your testimony today. I appreciate it. Okay, next up is it Alfredo Grower? I can't read the writing. Is there an Alfredo or an Aaron or? We'll move on to Andrew Cruz. Okay, just signed in. Perfect. Okay, Shelby Fraser. All right, let me work off the other list here. How about Stacy Taylor? STACI. Just introduce yourself and where you're from, and go ahead when you're ready.
Sure. So I wasn't planning on speaking today, but my name is Stacy Taylor. I've worked as a domestic violence advocate for almost 20 years now. Coming October, I will have met that goal. Just listening to some of the statements that have been made, and then some of the questions that y'all have had, I just wanted to just address some of the questions that you had. So a lot of the clients that I have seen, when it comes to child custody, judges are really leaning toward 50-50 custody. So I was an advocate up north, and then became an advocate down here about 3 years ago. So that trend of 50-50 custody is really something that has been very wanted, I guess, by the judicial system. But it also doesn't matter whether or not I've worked with clients that have been strangled in front of their children, strangled to the point where they were unconscious. The child was the one that called law enforcement. The case was dropped down to disturbing the peace. It was a domestic violence with traumatic injury and strangulation. It was pled down to disturbing the peace. I personally don't believe that if somebody's charged with strangulation that they should be able to plead it down to disturbing the peace. But anyways, in my field, I primarily work with females, but we also do work with any gender. But so I might say she or he, please forgive that. Representative Ehart, if I'm pronouncing that correctly, you had mentioned like people that are making allegations pretty close to the time of the hearing and stuff like that. A lot of people, there is a fear factor in disclosing things to law enforcement. One, because maybe they've called law enforcement a lot of times and they've been told that they were crazy, or if they would just get off the drugs that the abuse wouldn't happen. Sometimes their abuser is somebody that is prominent in the community, has very influential friends within the government. And so a lot of times things are not reported to law enforcement or to anybody. In fact, a lot of times they'll say, I don't even want child support. Don't give me child support. Just let me have my kids.
Okay, you can wrap it up if you.
The only other thing that I would say is that the people that are coming up here and testifying is not an unheard. It is so common. It is extremely common, and it doesn't matter where you are in the state of Idaho. So that's all.
Thank you for your testimony today. Do we have any questions? Yeah. Senator Nichols.
Thank you. Thank you, Stacy, for being here. Since you've been working with domestic violence and you're an advocate for domestic violence and helping people with that, are you ever sought out to help provide any types of evaluations or information or anything along those lines? Are you able to provide those types of services, or where's your role in that? Or do you just work with the males or females that come to you?
Go ahead, Stacy.
Thank you. So we provide support, and we also provide like community resources or resources ourselves. So we do not do evaluations. We are somebody that typically when law enforcement gets involved, they have their part. Prosecuting attorneys have their part. And then once the case is dissolved, then they're out. But we walk beside that individual through all of the processes, and until they say, I don't want your services anymore. So,
gotcha. Thank you.
Thank you for what you do. I don't see any more questions, so thank you. Next up, we're going to have Sarah Wolf. And after that, we're going to do Shirley Fraser. Hi. Introduce yourself and start when you're ready.
I'm Sarah Wolf. I apologize in advance. This is just so emotional. I've been separated from my children, my 4- and 6-year-old, for 9 months. And I didn't know that this problem existed. I've been a mom for 17 years. Never spent one day away from my kids, and it was my own domestic violent abuser. I went and got a protection order from Faces of Hope, and Stacy and her entity, Nampa Justice Center, also has helped me and my kids. And he broke that protection order and attacked me in my sleep, and committed a felony, and During that time, my special needs little boy, I didn't have him diagnosed yet, and so I agreed to let the dad have probation and ankle bracelet. They called it a safe plan, and it wasn't safe. And pretty much once he finished the anger management and the classes, the abuse picked back up. And so I started reaching out to Faces of Hope in August and September. I had called about 84 times, and he found out throughout that, made the relationship pretty bumpy, went out of town on a golf trip, and then came back off probation, and 29 days later filed a false protection order, and false allegations went to health and welfare. And I went through that investigation, and I was removed from our home, but also my teenager was stuck in the middle of that. She actually was served with a court process too by her own abuser. She actually had called 911 on him, and he told her, I would get rid of your brother and sister and get you and your mom out of here. And then we got that probation with that crime. And then he actually did do that to my little girl. So she had to actually be hospitalized. He dumped all of our belongings out in front of my 4- and 6-year-old in the winter. And then I think the most hurtful thing about sitting here today is that not one single of my court hearings have ever been what was talked about today. It smashed me, and then I'm a communicator, so the system's really quiet, and I found that my personality also was just didn't work well for me. I really struggled with an attorney. I couldn't get an attorney. I spoke up. I thought integrity mattered and laws mattered and like transparency mattered, but I realized it didn't. I even met the director of Idaho Health and Welfare, and I actually presented my case to them, how afraid I was for their department and what they do to the public. And they told me that they would fix it. And I worked with the Idaho ombudsman, Trevor Sparrows, who also met my daughter, and just, he knew too that it was just not okay. And he promised me, you know, hey, Sarah, we're working on the department. And I thought that they cared. And then I called, and all those employees still work for them. And not only that, I called our own attorney general and our governor's office, and they actually treated me so poorly. They hung up on many of my friends, many people who were advocating, and actually even an ICU nurse here at St. Luke's Hospital, where they completely disrespected her, hung up on her. I was made fun of. I was actually told that it made me look crazy to call, and I'd never called a leadership in my entire lifetime. But then also those children were killed by another parent. And so while I've gone through this, it's just literally been torture. And I just thought if I just emailed the right people that no one would ever just turn me away. My little boy has just never been away from me. It's just so obvious that this is domestic violence and that the court rules should have been followed. But then my judge has been asked to recuse himself. My judge has made fun of me. My judge laughed at me. He told me that I needed to get an attorney over and over and over again, where I'm like, I want an attorney. Would you give me an attorney? And then he laughed at me. He's like, I can't do that. Later on, then says, well, she could have asked for an attorney. And I'm like, but I did ask you for an attorney. A lot of dishonesty. And the biggest thing I'll say that I think we need to change is that perjury should never be allowed. I have over 33 counts of perjury. Also, this person's been violent to my children. My son tested positive for drugs in his hair. Also, CPS they were going to hold me accountable, but then when they find the correct parent, they didn't hold him accountable, where I could have corrected my case very long ago.
Thank you so much for your testimony today. This had to be tough. we're pretty far over, but I'm sure there might be a question or two. Just hold on a minute.
No problem.
Go ahead. Same question that everyone's been asking. What has this costed you besides your children?
And time.
Time and money.
I mean, I don't even know if that's measurable because a lot of it I went pro se. So I would say that it was rebuilding my life, but also coming up with money. I couldn't come up with it, so I got hurt the other way, which is violated completely, no protection. No one ever once gave my kids a voice. None of my children have gotten to be a part of any of it. No one's actually even asked if they're okay. So just mostly having accountability. And then I did file 3 judicial complaints among many other things that counted against me.
Follow up.
Go ahead.
Sorry.
So I'm sorry, Ms. Wolf. I understand that. I understand you probably didn't have a lot of money, but could you give, and I know the other stuff, could you give some dollar figure in your circumstance?
Yeah, I would say over the 9 months, it would probably be more around $50,000 to $80,000.
And that's no small figure. So 50 to 80,000. And Madam Chair, if I may, what time frame are we talking?
9 months.
9 months.
And that's also like, I also lost a lot of, you lose a lot of work because you have to go to a court all the time. And then like you lose a lot of money too through the process.
Another question I have that I just want you to clarify. So you're saying that your ex has criminal charges against him that were adjudicated, like he's a criminal.
He has approximately 26 charges. He actually also has trafficking heroin. Also, he's with a spouse that has about 25 charges that surround my children, including manufacturing methamphetamines and injury to a child. So yeah, these are like major crimes.
And so 26 charges, and then the judge said you don't get any custody?
Well, he made those false allegations.
Right, but I'm just saying, has those false allegations, they've been proved false.
Yeah, so it's just, I keep going. In fact, even the supervised visiting place keeps saying, like, how much longer are you going to come here? And then now, recently, he's now trying the reunification, and I'm like, there's no excuse for that. We need to go to standard parenting. Yeah.
We appreciate this, because this is how we can look at criminal code and...
Yeah, I mean, I can tell you that they're not doing that. And then the perjury in my case is just so extreme that when you allow perjury to happen, it keeps happening. And I also urge you to Google the silver bullet, because that's where it's actually on trend right now. And you go and dismantle your partner and commit perjury, because they'll say right there that you won't get in trouble for it. And actually, even attorneys are telling their clients how to fill those out to make sure that they go through. And he actually filed for 3 protection order petitions, all with perjury and omissions. And one of them was against a minor child that called the 911, and he was arrested on a $100,000 bond. So he went around and did that to my little girl too. So he's not just doing it to another adult. Yeah.
So sorry you're going through this, and we thank you for your being brave and showing up today. And
thank you.
Okay, thank you. Next up, did I say Shelley Fraser? Is there Shelley Fraser here? Shelby, maybe? Shelby? Okay, how about a Tom Kofoed? I know that's pronounced strong. You're going to correct me.
You did really good.
Okay.
I've got some literature I'd like to share with you.
What is this?
The victim's point of view.
Okay, maybe hand it to the secretary and they'll distribute it for us. Thank you.
No, I won't go along with the rest of the horror stories that I went through with what I call the criminal enterprise known as family court.
Will you say your name real quick for the record?
Sorry. Thomas Kofed.
Okay.
Reside in Parma, Idaho.
Okay.
And my divorce happened in Ada County. But there's about 4, a lot of crimes that judges are, about 4 major crimes that judges are, one of them is illegal discrimination from one parent, civil rights violation, extortion, and fraud upon the court. As I'm sure you're aware of fraud upon the court, if a judge just appears to be biased, the law disqualifies them from staying on the case. It's not the judge's choice, the law does it. And the solution to it is, and one of the problems with the legal abuse that is happening, in family court, it increases the suicide rate and homelessness. And in the best interest of the children and their families, to get the legislature's incentive to make their proper changes to prevent the legal abuse, that the parents should get united to file civil lawsuits against their judges. And to give you two examples on prove that we have the legal right to do that is there's an attorney in Alabama that has filed RICO conspiracy lawsuit against civil judges and family court judges and lawyers in Alabama. And another really good case is the Kids for Cash, where a little 14-year-old girl was brave and smart enough to get united with her peers to get their corrupt judges sent to prison. And they received a $200 million settlement for doing it. And another deal to cover is a lot of these victims say that they have to pay court vendors that the court appoints. But that, like I said, that falls under extortion. So they're not required to pay that because the judge does not have the legal right to extort money from them. And then, in my opinion, there should be an investigation to find out if the judges are taking any kickbacks from the victims. And chances are they probably are. Okay, that's all I have.
Thank you so much for your testimony. I don't see any questions, so I appreciate, just solutions.
Okay, yeah.
Yep. Next we have Heidi Moreland. Is Heidi out there? And then after that, we're going to go to someone on Zoom World, if they're still there, Diana Sanderson. Go ahead, Heidi, when you're ready.
Okay. Thank you all for being here and listening to us. For the first time, I'm feeling heard. My name is Heidi, and my case is active in Bonner County, North Idaho. I'm the mother of three, a 30-year-old adult, two teens, ages 16 and almost 15. I endured 17 years in an abusive marriage, and now my children and I are facing even more abuse, this time from the family court system. I am standing here today because just 1 month ago, in her final judgment, the judge took my kids away from me. And she stripped me of all of my parental rights with no warning and no opportunity to say goodbye. She completely flipped custody, giving full custody to my abusive ex. I was also ordered into an immediate blackout period. That night, my children were coerced, then ambushed, threatened with arrest if they tried to speak with me, and forced to leave their home with their father, the man that they begged the courts to protect them from. My children have always lived with me per the court order from the beginning of this case. They were thriving in my care. They had written letters to the court describing their father's emotional and verbal abuse, his rages, his insults, his manipulation, his public humiliation, and even his intentional reckless driving that made them both fear for their safety. At ages 16 and almost 15, they were never allowed to speak to the court. They cried out for help in their letters and some journals, and their voices were completely ignored and intentionally silenced by this judge. All of this happened because I was accused of parental alienation. And this judge based her ruling almost entirely on this accusation. She also based her decision on her disagreement with my religious beliefs. Parental alienation syndrome is a concept, it's a kind of trending concept actually right now, that has been widely discredited and is not even recognized by the American Psychiatric Association, the World Health Organization, and the American Medical Association, just to name a few of our big governing agencies. Parental alienation is not a valid diagnosis, and it's not even a crime in Idaho law. Yet this judge used this as justification to destroy my family. There was a so-called expert who testified against me by way of a written report. He was hired by my ex-husband. This expert never met me or spoke with me, never met my children or spoke with them. And he relied solely on all of the information that went into his report on my ex's very twisted and distorted narrative. The judge accepted this biased report as fact, putting a lot of weight on it, while dismissing all evidence from my children. She rejected their letters, she rejected the guardian ad litem's report, and she even accused me of writing my own teenager's words.
Heidi, we're at 3 minutes.
Okay.
So if you can kind of.
This wasn't justice, it was punishment driven by a judge who was biased, that was made clear behind closed doors. I was warned by attorneys, one who claimed to be the friends of the judge, who, quote, said, "She effing hates you." Several other attorneys confirmed this hatred towards me as well, and also spoke of this judge's reputation that if you cross her or if she decides she doesn't like you, you're done. My children are now trapped in an abusive situation and threatened to undergo more of the experimental reunification programs like the ones they've already been through. Their trauma is being deepened by a system that claims to protect them, but instead has silenced them and not protected them at all. This is not just my story. This is happening all across Idaho. This, as you've heard today, this is judicial abuse. I just want to say, lastly, that because my case is open, I stand before you today and I am very fearful of this judge's retaliation against me and my kids because I'm speaking out. Please implement laws that disallow this parental alienation, that terminate the judge's ability to court order reunification therapy, and adjust our laws regarding what truly is domestic abuse.
Thank you. We have some questions. I'm going to just share with the committee. We have at least 15 more people signed up to testify, and I see 4 lights on for questions. So I guess we'll do the questions, but please, I want to make sure we get to everyone. We've got to have a 4 o'clock hard stop. So go ahead, Senator Nichols.
Thank you, Madam Chair. Heidi, and remind me your last name again.
Moreland.
Moreland, thank you.
Moreland.
Okay. Can you tell me, so you were getting this information, sounds like there's a problem within the courtroom. Were you able to try to have your case moved to a different judge, or was there any process given to you to be able to do that?
I begged. I had 2 different attorneys during the course of this event, and both of them refused to help me. I've come to learn, too, that if a judge or if an attorney does try to help you get a different judge, they're committing career suicide. So they would not help me at all, and kept telling me I was stuck with this judge and there was nothing that anybody could do.
Okay, Representative Ehart.
Thank you, Madam Chair, and thanks, Ms. Norman, for your courage. So 2 things. First, with some of that which you shared and suggested, I'm assuming it is documented, proof. I mean, do you have documentation?
Heidi, can you respond?
Documentation of what? I'm sorry.
Clarify, please.
Yes, please. Thank you, Madam Chair. I'm trying to take notes. Some of the things that you shared that either the judge did or things that occurred.
Alienation?
Yeah. Do you have any documentation and proof that you can leave with us?
Nothing that I can. I mean, you can go into my case on iCourt. You can pull up I'd be more than happy to share all of the documents.
Sometimes
I have the recording of the hearing and the final trial and the oral decision.
And then, Madam Chair, the same question. Would you give us an idea of the amount of money and time frame that's been spent?
Okay. First, I'd like to preface that with saying the minute divorce papers were filed, I was completely stripped of 100% of my financial resources intentionally by my ex-husband. He drained every bank account and took every penny away from me. But first had made sure that he drained all my retirement accounts and everything else. So I had no resources. To date, I've been relying heavily on credit cards and a couple of other resources, a sale of a house that was court ordered. But to date, $100,000 approximately. And if I'm going to fight this, I'm being told it's going to cost several $100,000 more, and I don't have it. And I can't just sit here and not fight for my kids.
Okay, time frame, over how long was that?
Oh, about a year and a half.
Okay, thank you. We have a online, oh, he took his hand down. So we had a senator online that had a question, but thank you for your testimony today. And, oh, no, he's got it back up. He's got his hand back up. So Senator Bierke has a question. Go ahead, Senator Bierke.
I'm going to mute myself. I'm not a big Zoom person. Can you hear me okay?
Yes, we can hear you.
Madam Chair, thank you. And Ms. Moreland, very interesting testimony we're hearing today. And the answer to your very last question had me put my hand down because it kind of answered a question that I was thinking about. There's been some testimony about potentially where money is coming from to feed a potential system. And two, that the person who cares most about the children seems to be an implement to keep this going, to keep this fight going. And I'm not indicting the system just yet on what may be going on here. This has been, like I said, very interesting. But what I do, just a very specific question, what is your best explanation when they use parental alienation? What is it exactly? I have in my mind what that is. What is it exactly telling you? What do you think that they're referring to?
Go ahead. Did you hear that question?
Yeah, let me.
Like, when they say parent alienation, what do they mean by that?
They are accusing me of brainwashing my 2 teenage children to not like their dad, to not be with him. And one of the definitions of parental alienation, it specifically says parental alienation does not apply if there's abuse. Well, my kids wrote letters detailing lots of incidents where their father abused them, emotionally, verbally, mentally, lots of body shaming, public humiliation, bad driving, scary, yelling, rages.
Okay. Does that answer your question, Senator?
It does. That was what I was thinking. It just seems to be such a highly subjective indicator. Yeah, I appreciate that response, Ms. Moreland. I sympathize with what you're going through.
Thank you.
Thank you for your time today.
Thank you.
Next up, we're going to have Tyree. Is Tyree here? Please introduce yourself. Tell us where you're from and add in costs, because you're going to get asked that question if you can, if it's relevant. And we're just going to try to move through as many as we can. So thank you.
My name is Tyree Strong. I'm an attorney from Coeur d'Alene. I am also a survivor of domestic violence and coercive control. I was told, I'm speaking in my role as an attorney, not as a survivor. As such, I was told I would be having 7 minutes for my speech. I think you're wanting me to cut it down to 3, which is going to kind of make it not very intelligible. I just want to have that disclaimer up front.
Okay, just go as fast as you can, and we're not going to pressure you. So take the time you need. Go ahead.
Domestic violence is rooted in coercive control. One partner seeking to control, dominate, and assert power over another, undermining the victim's sense of self, will, and decision-making. One definition of coercive control is a systematic pattern of behavior that establishes dominance over another person through intimidation, isolation, and terror-inducing violence and threats of violence. Domestic violence is not merely isolated incidents of violence, as is the model for our current law. For many, it is the implicit threat of the violence to come that controls their every move, as their lives are micromanaged, they are isolated from friends and family, and financially abused that they are trapped without a way of escape. Leaving is devastating, hard, and sometimes fatal, as this is the most dangerous time in an abusive relationship. And yet, Idaho has no laws to protect these victims of control and domination, or their children, who also become targets of perpetrators. I was going to speak about several scientific studies. The references are in the notes I provided. They talk about coercively controlling fathers harming their children, the correlation between fathers abusing their children and men abusing their partners, and how coercively controlling fathers cannot co-parent. One I want to highlight is a recent study surveying outcomes of U.S. family courts that found that fathers who were found to be abusive gained custody of their children in a significant number of cases, and that when a mother asserted abuse, even when it was proven, she was more likely to lose her children entirely than if she did not make such claims. If she asserted sexual abuse, it was even more unlikely she would retain custody. Idaho's definition of domestic violence needs to be expanded to include coercive control. The federal government urged states to do so in its 2022 Violence Against Women Act, encouraging them to enact versions of Caden's Law. In brief, this act encourages states to improve child custody laws by restricting expert custody to those who demonstrate expertise in working with victims of abuse, limiting reunification camps and therapies to those which can be proven safe and effective, providing evidence-based ongoing training to judges and court personnel on family violence, including coercive control and implicit violence, and requiring that courts that make custody decisions consider past evidence of abuse. Currently, there is no training required for our magistrate judges to recognize coercive control or its harm. Several states have already passed laws to recognize the danger of coercive control, including our neighbor Washington State, and a number of others are considering legislation. I have the definition here of coercive control according to Washington State and also the National Council of Juvenile and Family Court Judges, but it is also in the handouts I gave you. Since coercive control is the foundation of domestic violence, a strong predictor of domestic violence, and itself more harmful than domestic violence, I urge you to add coercive control into the definition of domestic abuse in Idaho Code 396303. This would require coercive control to be considered in making custody decisions and domestic violence civil protection orders. I also urge you to require magistrates who make custody decisions to be trained in identifying coercive control and understanding its harms to children. This would significantly help protect our children and their mothers from the damage of coercive control, along with the other provisions recommended in Caden's Law. Thank you for listening.
Thank you so much for your testimony in committee. Somewhere deep in that document, there is a couple pages on coercive control, and we'll make sure we'll send another, some more information on where that's at in code. It's actually the very last document in that. Is there any questions? Senator Nichols.
Thank you, Madam Chair. I'll be brief. Thank you so much for being here, Ms. Strong. So is this a national trend that's taking place? Are we finding that this is becoming an issue in states, not just in Idaho, but other states as well, that we don't have correct definitions and we're not being able to utilize and put into practice the things that are going to help alleviate some of these problems that we see occurring? It sounds like, I mean, definite words have meaning, right? And definitions are very important. So do you see that as some simple fixes that we can make to be able to fix some of the issues that we have transpiring in family courts?
Go ahead.
Yes, Senator. I don't think that it would just fix all of the problems completely. I don't want to say this Band-Aid is going to fix it, but I think that this would make a huge step towards it. The provisions recommended in Caden's Law, which is also known as the Keeping Children Safe from Family Violence Act, are significant, and it is a nationwide issue. That's why it was put in there by the federal government. We've heard stories throughout today about reunification camps, reunification therapies, judges throwing out issues of abuse. These provisions that are recommended counteract that.
Okay, thank you.
Representative Gannon.
Thank you, Madam Chairman, and Ms. Strong. So, where does these definitions and statutes plug in connection with considering child custody, and in what other ways?
Go ahead.
So Idaho Code 396303 defines domestic abuse. Our child custody laws say that if you're a perpetrator of domestic violence, according to Idaho Code 396303, then the presumption of joint custody is no longer there, and instead there's a presumption of sole custody. So expanding that definition of 396303 would be a help. That's there for the definition of where I would put coercive control in. The other parts, I have not studied extensively.
Okay. Thank you.
Thank you for your time today. Okay, it seems that we have a representative from Arizona in the room. So Representative Keschel? Is Representative Keschel here? No. Okay, how about Senator Fincham? Please introduce yourself and thank you for coming to our state today.
Thank you very much, Madam Chair, members. If you don't mind, I'm probably going to exceed 3 minutes, but I've got a rather lengthy document that I've furnished a copy to each of you on.
We have that.
What I'd like to do is kind of recount what Arizona has already been through, which may help to inform you of whatever path you might like to take. Madam Chair, members of the committee, I'm State Senator Mark Fincham from Arizona. Thank you for the opportunity to testify in front of your committee on the topic of family court orders. What's the purpose of government? I know you guys know. I kind of doubt that the other two branches are fully informed. It's to protect the civil rights of the people. And after all, are children not people? We've heard a whole lot of discussion about lawyers, judges, parents. I think I've heard child mentioned maybe 3 times during this whole day. So the purpose of government is also not to impose bankruptcy to the detriment of families and children. After all, the resources of a family are supposed to be directed at what? Raising the children. I'm the chairman of the Arizona Joint Legislative Ad Hoc Committee on Family Court Orders. We've held 3 hearings covering over 20 hours of testimony from professionals and from families. Very similar. In fact, if I didn't know better, I would say that I'm standing in our hearing room about an hour and 45 minutes to the south by air. The earlier testimony of your judge, while informative and speaking in the language of what ought to be, did not address practice, what's actually going on. And a growing number of complaints have been made about court-ordered parental alienation, and I'll get to that. Somebody asked earlier about, is there a definition of that? It's actually come out of thin air, by the way. He spoke to protection of civil rights of the parents under the Constitution, but made no mention of the constitutional rights of children. I understand after speaking with some of your constituents, in fact, I'm getting calls from all over the country because of the hearings that we've had in Arizona, that the Meridian PD has allegedly told parents that, quote, children do not have rights. Well, I think you all know nothing could be further from the truth. One of you mentioned that divorce is big business, and is it Earhart, Madam Chair, Representative? That's a great pull quote, except I would go one step further, that child custody is even bigger. We have had a number of families, 3 to date, at the Arizona hearing, over $1 million. One over $3 million over 11 years. All based on something called a temporary order. I'll get to that in a minute too. For many months now, my office has received pleas from parents, minors, and even aged out young adults who would like to testify in Arizona but haven't had an opportunity to. And these are families and individuals from Idaho, Utah, California, Texas, and Florida, besides Arizona, about what appears to be a growing abuse of power in the family court systems. Clearly, we have learned that this is not just an Arizona problem, but rather a systemic issue rooted in the concept that family courts should be viewed as super parents and superior to the legislature, by the way. Whenever I hear the word rule, and I'm sure you probably have the same reaction, I hear something that is not legislative law, but perhaps ought to be. The superior nature of the legislature is that you make law, not the courts. And the legislatures have not granted such power to the courts, but the courts have taken considerable liberty in assuming that role. In fact, the courts seem to have taken on the belief that they are indeed super parents and have adopted what's called Polestar mindset collectively. Polestar basically equals the ultimate guidance of motivation for the court's decision in family court. It's the adhesive, if you will, the glue between statute and discretion, and the court's employment of the use of the words within the statute. And to explain the concept, Polestar basically, for the constitution of a contract in contract law, is the intention of the contracting parties is expressed by them in the words they have used. And that's Ames v. American National Bank. And I've got all the citations in the document that you'll be receiving. It's really important to understand this idea because Justice Thomas uses that in a Supreme Court case. By which the court, the Polestar by which the court has led to a decision is supposedly in the child's best interest. But we have heard a great deal of testimony today that perhaps it's not really, that it's an opinion of one person, and that's the one on the bench. The court uses the term Polestar interchangeably in a number of different fashions, but the court has applied its mindset in Hayes v. Gamma to say that the child's best interest is the primary consideration, or the Polestar, that North Star, that true North concept. So it's amazing that when reading all of these case citations and reading through the case law that involves them, employed terms or instruments, the idea, the presumption, or even appearance emerges that the judges have some divine authority to decide what's best for the child, quite often ignoring evidence, but going on the opinion of one person. Legal decision-making in the best interest of the child, which is an objective standard that prevents discrimination and preferential treatment through the use of objective evidence, ought to be that place where we go. But quite frankly, it's not. It's a very subjective thing that you've heard ample testimony about today. The courts in multiple states have come to rely on a fringe psychological theory known as COBE. And if you haven't received that yet, you're going to be pitched that to make it part of your law. It's court-ordered behavioral intervention. Now, we have on staff in Arizona a former family court judge who I think described this best. He said, well, if you think the court can order behavioral intervention and it's going to work, you might as well take $95,000 of cash, put it in the middle of the courtroom, light it on fire, because you're going to get the same result. You can lead a horse to water, but you can't make him drink. So this fringe theory and its practitioners, which frankly the whole concept flies in the face of the commitment by nearly every legislature in America to safeguard the best interests of the children, or the child, the minor children. The commitment seems to have morphed into the best interests of one of the parents in a perverse notion that forced reunification will accomplish what natural organic relationship building can achieve. The fact of the matter is it can't, because pressure breeds what? Resistance. Anytime you force somebody to do something that is against their nature, you yourselves are going to experience this. It doesn't work. These practitioners claim to be experts in their field. Yet terms like forensically informed and therapeutic interventionist are fiction created in the academic world and not the regulatory sphere. Look for that in your behavioral regulatory framework. Those phrases don't exist, they're unregulated. That means they don't have a standard of practice. No wonder they don't accept insurance. Because to accept insurance, you have to have a standard of practice by which you can judge, and that probably is where we see quasi-judicial immunity arise. We have that in Arizona, which originally in common law, the expectation is that is for people working in the court officers. Well, when the court abdicates its responsibility and assigns that responsibility into a psychotherapist or whatever, now they're relying on somebody who is not operating within a standard of practice. Do you see the circular conversation that's going on here with that? In other words, they are experts because they say they are the experts, okay? And they're not challenged for proof of efficacy, except by the good doctor who was here earlier today. And frankly, she testified in Arizona. And it was earth-shattering when media started to interview her. They were quite surprised to learn of the deficiency that we have in the regulatory framework for that category of psychotherapist. But they're not challenged for proof of efficacy, that the court accepts their assessments over solid evidence to the contrary. We have heard that several times today. Now, to illustrate this point, in the case of Gutierrez versus Honorable Fox, and this is an Arizona case, which will no doubt make it into jurisprudence, which your courts will probably take a look at. Court of Appeals in Arizona, even though it's black letter law, we have section 25-403. It's called the factors law, ARS 25-403. 12 factors that the court is required to consider when making a determination for child custody. Factor number 6, and it is kind of curious the way they have these numbered, but factor number 6 is domestic assault, and factor number 8 is sexual assault. Yet in this case, the appellate court said, well, you know, the court doesn't really have to consider that in a temporary order because, well, it's temporary. Except we have temporary orders in Arizona that have gone on 7 years. So that's one of the pieces of legislation that we're looking at, is trying to pen the court in, and I would urge you to do the same. Try to get temporary orders down to a minimum amount of time.
Senator, we've given you a little extra time because we know senators really like to talk.
I appreciate that, madam. I'm going as fast as I can through this thing, all right?
Well, we do want to make sure we get to everyone's testimony, but we do have some questions for you.
Okay,
I'm sure.
very good, ma'am. So with that statement, the appeals court basically chose expediency and protection of the judge or the best interest of the child. Because what happened here is this is a question of a temporary order where the child was placed with an abuser and somebody who was engaged in sexual assault because it was a temporary order. Now, I'll get on to the Supreme Court. In Justice Thomas's comments, this has to do with the United States versus Scrimetti. It has to do with the whole sex change thing. I won't belabor the point, but Justice Thomas basically came out and said, in fact, he noted in portions of his decision where the Supreme Court held Tennessee's law banning child sex change procedures, finding that said state law does not violate the Equal Protection Clause. A portion of the judge's or justice's written statement is, this case carries a simple lesson. Courts should not assume that self-described experts, key phrase, are correct. Courts should defer to legislatures over experts. That means you define what is acceptable evidence. That is exactly what the majority report in Arizona's committee is going to explore. We'll probably have a package of between 10 and 12 bills that are going to be very specific about some of the changes we make. And Madam Chair, I'd be very happy to share that with you once that's been produced. So another key statement, and I'll close with this. States have an interest in ensuring that minor patients have the time and capacity to fully understand the irreversible treatments they may undergo. This is their civil rights. Now, in this particular case, we're talking about an irreversible physical change. Mutilation of genitals, okay? But what about an irreversible effect on a child's mind? I'll close with the case that I'm very aware of. In fact, I've heard this case several times. You have an abusive father, perhaps an addiction to drugs, alcohol, whatever that may be. And you have a mother who disagrees with the lifestyle. And you have a daughter who's kind of conflicted. They want to have a relationship with dad, but dad's a drunk, abusive. But mother refuses to acknowledge that that lifestyle is acceptable. Instead, she stays silent, and she says, you need to go with your dad this weekend. In that moment, because she did not support the father's lifestyle, by definition, from some of these psychobabble providers, she just committed child abuse. It's been called that in Arizona, parental alienation. Madam Chair, I'm happy to answer any other questions you've got. The rest of the citations are in my report to you.
Thank you so much for coming, Senator. Representative Ehart.
Thank you, Madam Chairman. Thank you, Representative. Much appreciated. Hey, I'll try to, two questions, try to keep them quick. The first one was that, and so I'm wondering, because you've had this same problem. So we keep hearing the stories of the child being placed with the abuser, you know, from the parents. Most of these, obviously, most are women, but that's not the only case. And apparently, and I have no way of determining this, and we haven't gotten to that point to look, but apparently there's evidence that has been ignored. So I'm going to go with the assumption at this point that there's evidence that's been ignored. Is there a solution to this? Because that seems criminal to me.
Senator?
Thank you, Madam Chair. Representative Earhart. That ends up being the rules that you create. I don't want to go back and recite Chevron deference, but it's interesting that the court makes its own rules, and then the court interprets its rules and what evidence it'll accept. Okay, so we have a colleague in Arizona by the name of Alexander Culloden in the House of Representatives. He's a lawyer, and at first I had a bit of an issue with Representative Culloden killing so many bills, but the reason that he gave makes perfect sense. It's because the bills included rule-making authority within the bill for agencies. Okay.
We've experienced that.
So it stands to reason, to answer your question, madam, if the court has to come to the legislature for rule oversight, you're going to set the rules for what evidence can be accepted. Now, the other question I believe you answered, Madam Chair, if I may diverge just for a moment. I think you also asked what's the motivation for
I did.
this. Okay. All right. 2 words. Billable hours.
Sure.
It's that simple. It's billable hours for the psycho people. It's billable hours for the attorneys. And if you can't hem that in and say, okay, you've got a timeline that isn't indefinite, you need to be in a box. Now, one of the things we're looking at is 180 days. Get it done in 180 days because you're going to go from a temporary order to a permanent order.
Madam Chairman, follow up?
Go ahead.
So with some of the other testimony we've heard and then a couple of things you've said, from Arizona's perspective, from your perspective, who has jurisdiction over the judges?
Senator?
Well, that's a great question. Madam Chair, Representative Earhart, the state constitution in Arizona is slightly different than the state constitution here. There are a number of mechanisms we have in Arizona. One is impeachment. That's not going to happen because of the political division that we have within the Senate. Although, in a most egregious case, I don't want to preclude my Democrat colleagues from saying, oh, I can't vote no on this because if I do, I'm going to get thrown out of office. We have some egregious cases for consideration. But you also have to have a House of Representatives that's willing to write the articles of impeachment. And quite frankly, it's got to be a pretty, in the words of Speaker Johnson, it's got to be a pretty, at the congressional levels, it's got to be a pretty egregious thing. Well, I'm at the point, Madam Chair, Representative, I think we've arrived there.
I was going to say, Madam Chair, losing one's children is pretty egregious.
Yeah, so impeachment is number one. Number two is judicial non-retention elections. Now, judicial non-retention elections, which seem to me a rather curious means to insulate oneself from being thrown out of office. Perhaps, I'm pretty sure that if you, Madam Chair, or you, Senator Eccles, propose the idea of having non-retention elections for the legislature, you would think that the world just caught fire. Okay, so the other thing we have in Arizona, which I don't believe you have, is direct recall. If a judge has been appointed, takes 10% of the polity in which that area the judge serves to get on the ballot as an affirmative recall of a judge. Now, from what I understand, you do not have that here, but perhaps the legislature might consider a referral to the ballot if you don't get some kind of activity from the courts. One of the things that we don't have, Madam Chair, and I'll button it up with this.
Okay.
If you think back to the days when we went from the one-room schoolhouse into factory learning, this individual called the principal teacher showed up. It's now the principal, but the principal teacher was a coach, was the oversight of all the teachers within that school. And over time, that morphed into an administrator. But imagine what would happen if the presiding judge of the family court system didn't hear cases, but instead sat in courtrooms and coached the family judges on their behavior from the bench, on their interpretations of law, their negating of fact. Might we perhaps see a change in behavior? Because I think ultimately the family court is not going to go away, but it certainly needs to have some more direct oversight.
I'm going to cut you off. We have almost just about over 30 minutes. We have over 15 people that need to testify, and I definitely, we're going to be having more hearings, and we're going to hopefully have you Zoom in to present around the state at other hearings and share more of your findings in Arizona, and maybe we can collaborate amongst us with ideas.
Madam
So
Chair,
thank
I
you.
welcome the opportunity. Thank you very much.
Thank you so much for showing
your
up.
deference.
Okay. Next up is Shelby Fraser here, or Brianna O'Neill. I do appreciate everyone coming. I know you're going through a lot with your custodies, and so to show up here is taking time out of your day, and we want to respect that. So thank you. Introduce yourself and start when you're ready.
Okay. My name is Brianna O'Neill. I'm a mother and a victim of egregious judicial abuse. I stand before you today not just for myself, but on behalf of the many Idaho families who have been silenced and traumatized by this system. On June 10th, 2023, my youngest daughter was born. I made the selfless and very difficult decision to place her for adoption to protect her from a very abusive man. And I did so because of exactly why we're here today. The family courts don't seem to care or don't seem to protect our children. I followed Idaho Code 16-1504B to the letter. The adoption was lawful, complete, and finalized in Canyon County on September 1st, 2023. But when the putative father, who had not strictly complied with the law, filed a late, incomplete, and partial paternity action in Ada County, my attorney filed a motion to dismiss, given that the adoption had already occurred. That should have been the end of it. Instead, what followed was not justice, it was retaliation. On December 5th, I entered an Ada County courtroom and was met with hostility, bias, and presumed guilt. The judge, who admitted she had no jurisdiction over our case, still accused me and my attorney of committing fraud on the state of Idaho without ever even looking at our case. She then demanded that I violate a sealed adoption right there in front of non-parties in the courtroom. When I upheld the law and objected to revealing pieces of our case, she abused her authority and retaliated against me. On January 18th, 2024, I was called to the stand, threatened, intimidated, and ultimately thrown in jail for refusing to break the law. This was not due process. This was judicial persecution. After I returned from jail, the judge continued her campaign of harassment. She revealed our sealed adoption case number to the opposing party, coached his attorney on what to file, practiced her own version of the law from the bench, suggested Supreme Court cases that his attorney could cite, and encouraged him to file a bar complaint against my attorney. These actions emboldened the other party and took us back to court in Canyon County for another year to challenge the adoption. This caused brutal and unnecessary financial strain, emotional trauma, and heightened fear. On November 18th, 2024, she finally recused herself, but she wasn't done. She filed a bar complaint herself against my attorney, and before my attorney even had a chance to respond, she leaked that confidential complaint to the opposing party, which was just another gross abuse of her judicial position. She then proceeded to deny our motion to dismiss, regardless of her recusal and lack of jurisdiction, authority, and her boundaries. Still, the damage continued. The next judge...
You got 3 minutes if you can just kind of I know.
I'm almost done.
Okay, go for it.
Maybe.
Just talk fast.
The next judge, mentored by the first judge, mocked our Canyon County judge on the stand and on record, and said that she was dangerously close to having her paycheck withheld if she did not give her final decision on the challenged adoption soon. He delayed hearings and was preparing for trial even after we legally won our case on February 18th of 2025. And when I requested my records, the second judge sealed our case, not to protect my daughter that I had placed for adoption, but to silence me and to protect the judiciary. Let's be honest, the only ones protected inside private courtrooms and within sealed cases are the judges. The judiciary protects misconduct, they protect retaliation, and they protect unchecked power behind closed doors. As Lord Acton famously said, power tends to corrupt, and absolute power corrupts absolutely. Members here today, what happened to me is not a misunderstanding, and it was not just a bad day in court. This was a coordinated abuse of authority, a pattern of retaliation, coercion, intimidation, disinformation, and judicial overreach. I'm almost done. Idaho is supposed to set the bar for the United States, not lower it. We claim to value family, faith, and freedom, but those principles mean nothing if they are not upheld in the courtroom. I am Brianna O'Neill, a victim of Idaho's unchecked family court system. Justice does not belong to the robe, it belongs to the people. And today, on behalf of myself and everybody else here, we're here to take it back.
Thank you, Alana. Can you let us know how much you've put into this money-wise, financial, over what period of time?
So the financial burden has fallen primarily on the adoptive parents.
Okay.
I don't have that number. I'm sure that I can email you and provide that, given that I can reach out to them.
Thank you. Has this been over 2 years through the chair, please?
Yeah, so it's been within the last 2 years.
Thank you. Okay, we appreciate your testimony. We're going to go right to Alana Hamilton.
Thank you.
Please share your name and where you're from, and try to keep it to 3 minutes.
My name is Elena Hamilton. I am from Ada County. I was born here. My son was born in 2019, and when he was 4 months old, his dad sexually assaulted his 15-year-old daughter, different mother. It took, 6 months before he was arrested, and he spent a year Ryder up in North Idaho. It took years for our divorce to be finalized because he was in and out of prison. He was released from prison. He went through his treatment program. He broke his probation and by reaching out to the victim, and he was arrested again. So our divorce was pushed out once again. It was finally done in November of 2023. The judge's ruling said that his story was more believable than mine. And she awarded him our property, so I owe him $130,000. She did award me sole custody, physical and legal, because he was in prison. But she allowed phone calls on the first and third Sunday of the month. My son didn't know him. He had been gone for years, and he didn't want to talk on the phone. He would call after bedtime, not great times. His dad was recently released from prison in November of 2024, and he is taking me back to court to force the phone calls. And I have to sign a form that says he can have visitations with a minor, my minor. Our attorneys met with our judge privately, and she said she will enforce them. She will force me to sign the form that says he can visit my son. He's a registered sex offender. That's it.
Is this Bonner County or is this Ada County?
Ada County.
Ada County. And, wow, okay. Senator Nichols.
Thank you, Madam. Thank you. How old is your son currently?
He's 6.
6 years old. Okay. And when are you due back into court then on this?
My attorney called this morning and said that she would get the paperwork together. I don't have a court date yet, but it'll probably be soon.
Thank you for your testimony today.
Monetary is over $200,000.
Over
6 years.
6 years. Okay.
Thank you.
Victoria Devine. Okay. Probably put the sign down because we don't want to bring up judges, but, and you got three minutes. Thank you. Thanks. And I will just say right now, we will be having another meeting, and if you didn't get a chance to testify or you need to share more, you're welcome to Zoom in for the next. We're going to do 5 of these over the course of the next few months, and we want to make sure we have everything on the record complete. So please don't give up on us. We're part-time.
Thank you, Madam.
Go ahead.
Before I begin here today, I wanted to thank each and every one of you gentlemen and madam for being here today and to the people that made this happen. I also wanted to give a special recognition to Senator Alfieri, and I heard Senator Burek is also here as well. They're the senators of where my custody case has taken place in beautiful Coeur d'Alene, Kootenai County. I also wanted to thank Senator Fincham. You have no idea the gratitude that I have, and I'm sure we all have here for you being here today, because sometimes it just takes that one spark, that one group, that one ignition for change. And we have American children suffering, and it's hard to believe that this is happening on American soil. My name is Victoria Devine. I'm a mother. I have no criminal record. I have 0 history of any drug or alcohol issues, no mental health issues, no abuse concerns. I actually worked as a court-ordered visitation supervisor through social service agency through DCYF in Spokane County. I protected children for a living. What has happened to my daughter, as I face in my own custody case against the habitual domestic violence abuser, her father, is unspeakable. If this can happen to me, I don't think any of us are safe. And the judge, well, I guess I'm not supposed to say his name, it would take a very easy search of him in Kootenai County, because this judge, if you pull his name up on a simple Google search, has been judicially disciplined by the Idaho Judicial Council 4 different times. This man showed no respect to the decorum of a courtroom. He walked in a Star Wars mask with Star Wars music playing. Imagine you come in as a parent or a murder case of serious decorum required, and you see something like that. That to me is someone who takes their job as a joke, and that's how he has treated my daughter's case. This judge has had evidence in his hand for over 6 months that my daughter is being abused. Her therapist called CPS on her father 5 different times to report his abuse. Justice delayed, as we know it, is justice denied. That means that my daughter, this innocent 5-year-old child, is left in abuse. What happened with CPS in Kootenai County needs severe and serious investigation. And I say this also having worked through DCYF. I had a prior judge before this judge came onto the case who actually took his job seriously. And he ordered these court-ordered investigations of CPS. Well, what happened at these CPS investigations, it would make you fall out of your chair, honestly, any reasonable person hearing what has happened. My daughter, because these CPS interviews, they get recorded. There are these forensic interviews. And my daughter disclosed to the CPS caseworker, Daddy hurt me, he hit me. She actually showed the caseworker an injury that she sustained from her father. And this is all recorded. I have the transcript here of that. When I got the report filed, like it was filed through the court, again, I almost fell out of my chair. The caseworker did not she submitted a falsified report to the court that there was no abuse. So there's crimes being committed, and there was a crime committed in my child custody case. And what that means is it's a simple comparison analysis. You take the audio, you listen to it, and you compare it to the report. Well, where's that in the report that my daughter told them multiple times that her father is abusing her? The judge did nothing about this. Our own prosecuting attorney's office won't even work with this judge. This judge is not allowed to handle criminal cases in Kootenai County. So if this man cannot rule over in criminal cases, why is he allowed to destroy our children's life? He can't do his job, it sounds like. Again, 4 times judicially reprimanded by the Judicial Council here through Boise, and he still sits on the bench. What happened next with this judge is, I thought the worst of it was this CPS situation. I am now having to be prompted to myself contact the Judicial Council here in Boise to open up and possibly maybe work with the prosecuting attorney's office in Kootenai County to launch a criminal investigation into this judge. Why? Because this judge, one of his reprimands was that he falsified his vacation time. So this judge had no problem falsifying records to his own judicial branch. He did it to me. So what does that say if he was able to, he had no problem lying to his own judicial branch? He had no problem doing it to me. And what I mean by that is my daughter came home with an injury supported by a doctor's report. It was around Christmas time. I'm sorry, I'm almost done. She disclosed abuse. Oh, okay. Thank you. Yeah. She disclosed abuse that her dad smashed a Christmas star on her head. I looked at her scalp and I noticed a scab. I immediately took her to the doctor and it was reported to police. Part of that, I know that my ex had home video surveillance footage in his home, so I subpoenaed those.
and he did not turn them over. I asked for the preceding dates of when the visits he had just before the injury was discovered. The judge falsified an order that my ex provided the home video footage when he did not. So he basically, he intentionally obstructed justice and committed a crime to say he falsified an order that to exonerate abuse because of the bias that he had. I've reported him. There was news sitting in the courtroom in Kootenai County. He knew about
cut you off.
Yes, of course.
Just
Sorry.
because we really want to get to everyone else.
Yes.
We will be in Kootenai County
Perfect.
on the 30th of this month. So at the end of this month, we'll be up there for another hearing.
Thank you so much.
I would love it if you could come back there. Very, very quick. Go ahead.
Thank you, Madam Chair. Victoria, thank you for coming all the way down here to testify. I appreciate it.
Thank you, Senator.
Just real quickly, have you been in touch with Pastor Remington
I apologize. Oh, who were you saying?
in Coeur d'Alene on this judge? We're talking about this. He has an issue as well, and I'm wondering if you've been in touch with him as well.
Sorry, I didn't hear the name. That
Have you
said.
been in touch with Pastor Remington?
I have not even heard, I haven't heard of him. I would
I
love
want
to.
to talk to you afterwards on this. Thank you.
Thank you, Senator.
And how much money have you put into this so far?
My parents, of course, they love their granddaughter, sold their house. $200,000, I'd say. Just gone like that. And this man still, this judge granted 3 overnights to an abuser where there's objective evidence of abuse. The bruises, the videos of him choking me while I was 8 months pregnant with our daughter, and her therapist saying she's being abused, and seeing the objective evidence that my daughter told CPS, the tapes that her dad's abusing her. There's a crisis in Kootenai County. Here, it's national.
Thank you for your testimony today.
Thank you.
How long has this been going on for? Over a year?
So we've been on temporary orders. It's like the same story over again. We've been on temporary orders, I want to say, for a year and a half now.
Thank you.
Thank you so much.
Okay, we're going to go right to Kelly O'Toole. Is Kelly here? Say your name and where you're from, and just...
My name is Kelly O'Toole, and I'm from Boise. I appear here as someone who has endured firsthand the failures of family court. I have been accused of alienation, a theory supported like law. Family court has turned my life into a nightmare, specifically related to family court. In the last 4 months, I've spent nearly $30,000. I've spent over $100,000 trying to defend myself and my children. I've been treated like a criminal. I don't have a record. I'm a registered dietitian. As it relates to my experience with the judge, I could write a book of all the injustices he has done to me and my children, and believe me, it's a page turner. This judge uses the theory of alienation versus facts and findings in his decision. The judge practiced a theory in my case, the theory of alienation, and has ignored law. He has shown bias, prejudice, and harassing behavior. He has acted without competence, diligence, or fairness over the last 3 years, where myself and my 3 children have been terribly mistreated. He has broken my constitutional rights with his radical rulings and has not followed due process. He is a former defense attorney who, from my experience, always defends a criminal. He has denied nearly every motion that I have set before him and allowed each of the motions set forth by the children's father. The children's father was charged with a felony of domestic violence with traumatic injury in the presence of children and injury to a child. The father was issued a no-contact order with myself and my 3 children. Within 8 months, the children were forced into reintegration therapy, removing the no-contact order issued in criminal court. There has been ongoing reported abuse from him by the children, including but not limited to their father throwing my 16-year-old son against the wall while the other children watched, throwing each of them out of his home one by one, telling them he doesn't want to see them again, then demanding them back days later, threatening them with police involvement. The judge has enabled the father to grab them by the neck, pin them down, lock them outside in freezing temperatures, isolate and harass all of them, threaten to beat the living shit out of them if he could, drive them around aimlessly, for hours at a time, screaming and ranting at them that they're going to go to jail if they run away, and more. Over 3 years, my children and I have suffered irreparable damage. The judge's judicial decisions that ignored the voices of my children, dismissed evidence of domestic violence and child abuse, and failed to enforce due process. His court-appointed CPS recommendations, brief focused assessment findings, makes decisions without court-appointed reintegration therapists, and has lost control of his temper in the courtroom. He allows cruelly biased testimony and uses them in his facts and findings, seals documents, and has had judiciary communication and his extrajudiciary communication in his quarters. He shouted in the courtroom that he was going to jail me and my children, or fine me heavily, or do an unknown blackout period, which is exactly what he did on March 11th, 2025.
As a reset in Mitch's and McKay's relationship, I
Okay, we need to, you're at the 3 minutes.
Okay.
write the judgment of the findings of fact and conclusions.
I just wanted to play this where he threatens to jail me. So right now, I have a no contact order with all 3 of my children. It has been issued as a temporary order, and it was supposed to be taken. It was supposed to be taken down 48 days ago, and it was only supposed to last 42 days. It has now been 108 days. The judge has delayed writing the order.
Is this Ada County?
This is Judge Scow.
Which county is this?
Ada County, the man that testified here this morning.
Thank you. We're going to move on. We thank you for your testimony today. And I would encourage all of you to, if you do not get to testify today, leave your name with the secretary up front, and we will make sure that you are the first to be on. We will contact you specifically and get you onto the next one. Christopher Morrison here? Not here. Is there anyone left online, or did we lose them all? 2? Is Anna there? Will you call Anna? Anna Green? Also, while Anna's getting on, if you have any testimony, you can leave with the secretary, or you can email it in. We'll take all that in, so the committee members all have it to look at when we start looking at policy and laws. So Sarah Browning's not here? Not here? Ah, there she is. Anna.
Hi.
Hi. You have 3 minutes, and we appreciate you calling in today. Go ahead when you're ready. Say your name and where you're from.
My name is Anna Greenwood, and I'm from Lemhi County, Salmon, Idaho. I don't have anything prepared to say other than I entered the system in 2023. I was a victim of domestic violence in the presence of minors. I do have to say the police here in Lemhi County were phenomenal. They got me set up with a victims advocate center here in town. They believed me. They filed charges immediately, and they saw me and my case the whole way through up until conviction. My judge has also been amazing. I entered a marriage that he already had 2 little girls, and the little girls lost their mom to cancer. So I was basically the mom in the situation. The older girls were being abused by him, and so that kind of sparked the final physical assault. And when the judge heard all of the information, he granted me temporary guardianship of the oldest child, which is kind of unheard of because I didn't have any rights to her. And so he did an amazing job protecting her, protecting myself. But I was kind of shocked to see that after that, I just kind of became the status quo. My two little children that we have shared custody of after the protective order expired, it was kind of like, well, he can see the kids every other weekend for unsupervised visitation. And I was just kind of stunned that that was just the status quo. And so I do have to say I've been treated very well by the system, but I see huge holes in the system that I'm like, well, I need to start speaking up. So actually, last fall I decided we need to have some sort of law in Idaho that matches Caden's law. I don't know if you guys have heard of that law. It's I believe it's a federal law, and it's starting to be passed in multiple states. I believe it was just passed in Tennessee, in Utah. I think it's Ohm's law in Utah that it was just passed in the last 2 years. I think Arizona has passed Caden's law as well. Anyway, it's a law that looks more at children's protection over parental rights. And if a parent has a history of domestic violence or abuse charges, then they no longer automatically get custody or visitation. It usually defaults to supervised visitation. And what's ironic is I was starting to look at who can I reach out to help co-sponsor this bill. And a lot of you showed up on my list. So I'm really excited about this.
You know, we thank you so much. Your time's up. Perfect timing. That has got brought up today, and we hope you'll still be in contact with us. We'll be doing more meetings, and thank you for your testimony today.
Yeah. Okay, thank you.
All right. Diana Sanderson, is she online? No, she's not online. Okay. Christine Morrison. I'm going to try to fit in two more. Is Brandy Holiday here? Okay, we'll have you go next after Christine. There's Christine. Christine, we can't hear you, so you're on mute. Still on mute. Okay, we can't hear you, so we're going to go to someone else. We'll come back to you when we're done. Brandy Holiday, can you try 2 minutes? Can you try fast? That would be awesome. Thank you.
Yeah.
Share from the heart, quickly.
Yes. I'm going to time myself. All right. Thank you, guys. I'm going to talk loud and fast. I'm Brandy Holiday. I live in Meridian, Idaho and Caldwell, Idaho. I'm a resident of both Ada and Canyon counties. I am a licensed realtor, been practicing here for over 15 years. I'm here today because the family court stripped me of my rights, my voice, and my relationship with my daughter without cause, without evidence, and without justice. I did nothing wrong. My daughter was taken from me. I was placed on supervised visitation. My child support was set without any connection to anyone's actual income. I wasn't allowed to submit a parenting plan or attend mediation. All professional evaluations were ignored. Decisions were made based off of sealed records and unrelated cases. Hearsay and even news media articles were submitted as facts and not laws, because of course everything you read in the news is true. I am a Christian, and I was judged because of both my marriage and my religion. I was treated with bias. My faith and family structure were used against me in court. That discrimination shaped the outcome of my case. This is not just justice, it's prejudice in place. I think many other people have said, you know, my attorney refused to ask for a new judge. Immediately after our trial, the judge, both before and after, was meeting privately with the attorneys. My attorney wouldn't disclose what those conversations were about. After that, I was required supervised visitation, where I wasn't allowed to talk to my daughter for 61 days. And at 3 years old, she didn't understand why we weren't going to the park that weekend to go feed the ducks. And I couldn't call her to explain. And it was another 6 weeks before I could even get supervised visitation. This summer, the judge recused herself, and I have a new judge. And the first thing he said was, this shouldn't have taken this long, and there's way too much in here. And that's time.
Thank you so much. We appreciate your testimony today. How much money have you spent on trying to get your kids back?
So far, I'm out about $20,000. Recently, the judge who recused herself had actually called a hearing to decide if I was going to pay the co-parents' attorney fees to the tune of $40,000. But now that I have a new judge, he decided that I will not be paying my co-parents' attorney fees, and that is not justified based on our case and findings. So I will not be paying his $41,000 in attorney fees. And we have been there since the 2022 to present.
Thank you. Thank you for everyone who showed up today. I know we didn't get to everyone. I apologize. We will be having another meeting on the 30th of July. And if you give us your names, you will be the first to Zoom in, and we'll give you extra time. How's that? Just give you a few more minutes. So we apologize we did not get to everyone. And we just thank you for coming out today and sharing your stories. And with that, we're going to be adjourned.